in touch with him.
Just contact me.
Whatever it is, post this matter on Monday. By the time, whatever instructions the petition wants to obtain shall be obtained. No further adjournments. Yes, call the list.
Please, here for the petitioner in this matter,
Hmm.
the advocates on record are no more. Their name may be deleted and my name may be.
Your name is?
Vinay Hosmat.
Oh,
Please.
it will be done. Yes.
Petitioner is the plaintiff, filed suit for partition. Suit schedule items are 25 in numbers. Petitioner and respondents number 18 to 20 together, they are the plaintiff. They had filed a suit against the other respondents. In that suit, they filed an application because some of the properties were acquired by the Karnataka Housing Board. So they filed an application to remit the amount before the court. After remittance, the respondent number 2 to others herein, they filed an application to withdraw the amount, stating that since the claim of the plaintiff is only with regard to their share of 1/4, so 3/4 of the amount remitted in the before the court may be disbursed to us, for which we filed objections.
What are the objections?
We filed objections stating that if the matter has to be first, we have to get to know as to what is the share, and they've already taken little bit of amount before. So if they are going to be disbursed with 3/4 of the amount, then let us also get the 1/4, which they say that, they have no objection, stating that since we have filed a suit for claiming 1/4.
Let's see.
Please, madam.
Let's see the order. please.
Objections is at annexure E,
No,
madam.
first we read the order, then we'll go to
Please,
the
madam.
objections.
The impugned order is at annexure F,
Yes.
and you want me to read it from the reasons, my lords? Page number 46.
Yes.
Para 7. The present suit is filed by the plaintiff seeking the relief of partition and that claiming 1/4 share over the suit schedule properties. But the present application is filed by the above said defendant stating that item number 2, 5, 6, 8 and 10 were acquired by the Karnataka Housing Board and accordingly compensation amount was deposited. But the present suit is filed by the plaintiff seeking 1/4 share, and these defendants further contended that they may be permitted to take the deposited amount by leaving 1/4 amount which is said to be claiming by the plaintiffs. It is further stated that as per the observation made in writ petition number so and so, the Honorable High Court of Karnataka directed to file necessary application to withdraw 3/4 compensation amount by leaving 1/4, which is said to be the share of the plaintiffs. On careful perusal of the materials available on record and
Oh,
also,
this WP number 226760/2015, you're not a party.
I was a party. This was filed by the respondents herein.
That's what, there the court said
Please.
that the necessary application to withdraw 3/4 compensation can be filed by
Make a
them.
necessary apply, please, my lord. I have, in my objections before the trial court, I have stated that let them not take, and if at all the trial court says that, let them take the 3/4, the rest 1/4, let them disperse it to me. That is what my objection states. On careful perusal of the materials available on record and also observation made by the.
For that, you have to ask,
Please.
you have to file an application for that.
No, I had filed it in my objections itself. Wide annexure E, your lordship may kindly turn to ink page number 43. I have stated that if the trial court is going to allow their application, I do not mind, but let them disperse 1/4, which they also state that, 1/4 is what I am claiming.
My lords,
You
here,
cannot have any objection for that.
my lords, the thing is, the 1/4 is the subject matter of the dispute.
How can it be?
My lords, 3/4 is our share. We don't have much objection towards it. If you
If 3/4 you say is your share,
I
what will
have no
remain?
objection towards 1/4.
For
because
that.
I'm not claiming.
So for that reason, writ petition is here from 2018.
Lordship may kindly see my
Oh,
objection.
unfortunate. Yes, please come. By this time, your suit would have been disposed of.
No, there is no stay, my lord. The suit is going on.
What is going
Going
on?
on, please.
Yes, please come. What is the stage of the suit now?
It is for arguments,
Suit of 2013, arguments in 2024.
please.
The present application is filed. Agreed with the orders passed in I number 8 in OS number 600 of 2013 dated 2/3/2018. Whereby the court below had allowed an application filed by the defendants to withdraw 3/4 of the deposited amount. Next paragraph. By so and so the court name. And order is 2/3/2018. The respondent herein, the petitioner herein is a plaintiff in the suit. He has filed the suit for partition in separate question. It is a case of the defendants that some of the suit scheduled properties are acquired by the Karnataka Housing Board, and the compensation amount is deposited. And what he is claiming 1/4 share, as such the remaining share they may be permitted to withdraw. In the writ petition that has come up before this court in WP number 22676 or 2015, this court had observed that the defendants can file a necessary application to withdraw 3/4 compensation amount by leaving 1/4. Which is said to be the share of the plaintiffs. What is it? The share of the plaintiffs. The defendant has filed his objections. The plaintiff had filed his objections, stating that where are your objections?
Lord, Annexure E, my lord.
Page number.
Page 41, starts from 41. Your lordship may kindly turn to 43, para number 6.
It is stated that as such, without prejudice to claim their right in respect of other properties, the amount deposited in respect of said properties will be released as per their share. Hence, their share may also be released in the case. If the defendants are not consented or seeks to release their share in that event till dispose of the matter, the amount shall be kept in deposit. With the deposit, the court below, by order impugned, had permitted the defendants to withdraw the money. Land counsel submits that when they have filed an objections to that, the court below ought to have allowed the plaintiff also to withdraw the amount. Land counsel for the respondent defendant submits that they wanted their share and they filed an application, and the plaintiff had not come up with any application. In their application, that issue cannot be decided, considering the submissions on behalf of both the parties, as the court has already permitted the defendants to withdraw 3/4 of the share, and the remaining 1/4 share is lying, subject to the further orders to be passed by the judgment and decree to be passed by the court. The plaintiff is also entitled to withdraw the said amount. You are the same, the petition disposed of, directing the petitioner plaintiff to come up with an appropriate application, and the court shall permit the plaintiff to withdraw the amount. This petition is accordingly disposed of. Yes, next.
Milords may appear for counsel for petitioner. Milord, this is the matter where Milords, I complain Milords with the order, include order. Wherein Milord, the trial court has Milords called upon the plaintiff and the plaintiff writ petition.
Let's see straight away. First, let's go to the impugned order.
Please, Milord.
Then you can.
Kindly turn to Milord's page 34.
Page 34. Yes.
Milord's annexure A, page 34.
Star set.
It's Milord's para 20 Milords, would be relevant.
No, let's see from the beginning
From the beginning.
to understand what it is. What is the suit for?
Milord, suit for specific performance of agreement.
Hmm.
There was no oral formal agreement which was entered into, but there was a power of attorney and an affidavit regarding the prior transaction of the parties. I paid Milord's rupees 67 lakhs to the owner of the property. It was for the purpose of joint development agreement, but under Karnataka Land Reforms Act, unless the land is converted, I could not enter into a full-fledged joint development agreement. In this case, Milords, I entered into a power of attorney. Power of attorney does not say possession is delivered. Power of attorney says that for powers are given and there is no power to sell was given. There was no part performance, possession was given. Therefore, Milords, there are two documents which came into existence contemporaneously. All that learned judge says.
As per the power of attorney, what are the rights that are given to you?
Milord, the rights given was to apply for conversion, to lease and mortgage. But my lords, under Article 41 of Karnataka stamp schedule, the word used is to sell. My lords, learned judge says, my lords, may I read my lords, operative portion. It's a very short order, my lords, I can read 2-3 paras.
Registration Act. Yes, Stamps Act. Yes,
My lords may kindly turn to my lords, 41E.
no, first let's see the reasons.
Yes, yes, my lords, I will take your lordship to reasons, then my interim application. I take my lords
Registration
to,
Act. Oh,
may I take my lords to the impugned order, then my lords application and my objection. Then my lords the legal question. May I read my lords the order?
yes,
The last portion of the order, my lords. Then I will come to the body of the order. Para 20, page 34.
yes,
As already noted above, the plaintiff has paid stamp duty of 220. The sale consideration amount of rupees 67 lakhs. 5.5 or 6% of the market value of the said amount comes to 3,75,200, which is the proper stamp duty payable on the above documents. After deducting rupees 220, the duty already paid, the deficit stamp duty payable by the plaintiff in respect of the above document is rupees 3,74,980. The said amount attracts 10 times penalty under Karnataka section 34 of Karnataka Stamp Act. Now, my lords, the concluding part of the order, the proper stamp duty rupees 3,75,200 less the amount of duty already paid 220, deficit stamp duty 3,74,980 plus 10 times penalty on deficit stamp duty is 37,49,800. Total duty and penalty payable by the plaintiffs in respect of the above impounded document dated 31/12/2007 is rupees 41,24,780.
yes,
May I read, my lords, can you turn to my lords, the reasons part of the impugned order, page 26. May I take your lordship back to the reasons part of the impugned order. There are 7 minutes. According to the defendant, the
Yes.
plaintiff has filed the above suit for the relief of specific performance of agreement by way of affidavit based on the unregistered general power of attorney and affidavit dated 31/12/2007. The above case has been posted for plaintiff's evidence on 24/3/2016. Thereafter, the matter has been adjourned for plaintiff's evidence on 8/8/2017. On 8/8/2017, the plaintiff in the, well, this is the application made, extracted by the Honorable Court. On 8/8/2017, the plaintiff, in order to escape from the duty and penalty on the said unregistered affidavit and general power of attorney, and to avoid the same, filed 3 applications, that is IA under Order 39 Rule 2A, IA under Order 1 Rule 10 CPC, and under Order 38 Rule 5 CPC. Now the matter stands posted for filing objections to those said 3 IAs. The plaintiff's case is based on 2 unregistered documents, that is notarized affidavit and notarized general power of attorney, both dated 31/12/2007. In the notarized affidavit, the payment of consideration, initial consideration, will be 67 lakhs, has been shown, stating that the said amount has been paid to the defendant by the plaintiff's firm. Affidavit is an agreement. The plaintiff, without having such enforceable document to file the suit, has filed the present false suit based on the above said 2 documents, which are contemporaneous to each other. General power of attorney has been referred to in para 7 of the affidavit, and therefore both the documents are contemporaneous to each other. Clause 9 of general power of attorney would attract duty and penalty, and therefore plaintiff is liable to pay duty and penalty on the consideration shown in the affidavit. It is 31/12/2007. Now my objections.
yes,
Only one para I will read, I will not read the entire document. The plaintiff filed objection stating that the matter is at the stage of evidence. The application filed at the stage when the impleading application filed by the plaintiff is pending. Now the defendant has moved this application to frustrate the application filed by the plaintiff for breach of injunction. The defendant is not respecting law and hence he is not entitled for any relief. The case laws laid by the defendant are not applicable to the facts of the case. The documents which are to be construed by the court only after evidence of the parties. Since the name, title of the document are not applicable and only contents of the application are required for construction of application. The instant application is devoid of rights and liable to be rejected. The notarized general power of attorney dated 31/12/2007 and notarized affidavit dated 31/12/2007 are duly stamped and entirely in accordance with law. The stamp duty paid on the aforementioned general power of attorney and affidavit are in accordance with the prescription made under the Karnataka Stamp Act 1957, and it is ascertainable from the original document itself. The defendant has filed the application to divert the attention from the serious fact of his willful disobedience of this court's interim orders that have been made absolute long back. On 11/1/2016, the defendant has entered into registered deed of partition. Of course, it deals with subsequent developments in the suit. They have entered into partition and all. No, my lords,
Let's complete it. Let's complete and then
no,
make
that
your
question,
submission.
yes, I read. There's no hesitation for reading. On 11/1/2016, the defendant has entered into registered deed of partition in respect of the suit shall property, which was registered on 22/2016. By document number,
Yes, please.
document number JL
Yes,
104351/2015-16, stored in CD number JALD 216, book number 1. The defendant has no regard or respect to law, and he has created third-party rights in the social property in direct and willful disobedience of the interim orders passed by this court in the instant suit. On the basis of fraudulent registered partition be registered on 20/2/2016. Referred to above, the defendant has falsely claimed that the social scheduled property is a joint family property. The instant application is blatant delay tactic designed to prevent the progress of the trial in the instant suit and to escape from the clutches of law for his misdeeds. Application is also attempt to divert the attention from merits of the case in the
yes,
instant.
I've seen it. Yes.
Anyway, that portion was not relevant to the stamp letter. That was my submission. Now kindly turn to my lords.
According to you, what
Yes.
is the stamp duty that is required on that?
My lord, according to me, my lords, since the first document was a general power of attorney, it was made only to facilitate conversion, only to go further. Like my lords, in every contract, contract can be general, contract can be specific, contract can be oral, contract can be in writing. But in this particular case, we have entered into, my lords, a term, it is better than, it is slightly improvement than term sheet. In the commercial transaction, lordships are aware that there will be a term sheet, then my lords, MOU, or this is a document facilitating regular joint development agreement on conversion. There is no conversion, my lords, in this property. It was an agricultural property. Secondly, my lords, the power of attorney, your lordship may kindly take, my lords, the document itself, so that there will be more clarity in my submission.
Page number.
86 relevant portion.
My lord, 86, my lords, 84 it starts, my lords.
Yes,
General power of attorney.
yes.
My lord, the powers in the second para I will read, my lords. To effect conversion of the scheduled property from agricultural use to commercial use, for the purpose to appear before all the revenue authorities, sign all the necessary proformas, affidavits, documents, papers, etc., as required by the revenue authorities for effecting conversion, and also to pay necessary conversion fees, etc., and to get the conversion order in accordance with the Karnataka Land Revenue Act and such other laws in force in Karnataka. Para 2, for the developer and any of its authorized representatives, nominees, agents, employees, laborers, etc., to enter into scheduled property and to take all actions necessary for the purpose of developing the bare shell for the commercial buildings on the scheduled property, 50-50 ratio. To obtain necessary permission, plans, sanctions, modifications, such permissions, plans, sanctions from the appropriate authorities, so as to facilitate the development of
No,
scheduled property.
according to you, this falls under which provision of the stamp?
Yes,
Act?
my lords. My lord, according to me, my lords, 41 schedule, 41A, my lords,
There is
41.
another book.
41E, my lord. Karnataka Stamp Act, 41E.
Let me read, my lords. I will submit, my lords, which is applicable according to me, my submission. Your lordship. Please. My lord, Article 41 deals with power of attorney. 41 schedule.
Article 41E.
My lord, Article 41. When executed sole purpose of procuring registration, it is not okay. Put it. I put it.
No, no, it's here, Article 41.
41, my lord. This Article 41 deals with power of attorney.
Hmm.
There are 4 or 5 clauses, my lords. The first clause is not applicable because it is for the purpose of registration of deed in relation to single transaction for admitting execution one or more such documents, not applicable. when authorizing a person or more to act a single transaction other than the clause mentioned above, A. Kindly go to C, my lords. C is also not applicable. Kindly go to 41E, my lords.
Yes.
When given for consideration and or when coupled with interest, authorizing the,
When was this agreement entered?
that was in 2007, my lord, December 2007.
Hmm. I think this clause E is by Act number 9 of 2009.
Yes, my lord. Yes, my lord. See, this is the problem, my lord. This is the error committed by the learned child here. So the law which was prevailing, my lords, the last amendment was in 2007, April. 2007 April law will be applicable. I fairly concede. But my first attack on this order is, first instance, my lords, this is a power of attorney. It doesn't give any possession. It doesn't per se has the effect of a registered to be registered joint agreement. It's a simple transaction, my lords, authorizing a person. I am a company.
How can you mortgage a property without any authority? What is mortgage?
My lord, mortgage is a specific interest, transfer of specific interest in the immovable property is mortgage. That's a
So
transfer of
how
property.
will you transfer the interest in the property to other person when you do not have?
My lord, this power of attorney, according to me, my lords, power of attorney and affidavit, which records a private transaction. No doubt I paid 67 lakhs. That is forthcoming in the affidavit. Because I could not protect my right in a better way than that of these two documents. Because it was an agricultural land. The law prevailing then was strict. Unconverted land, a company could not enter into any agreement. No, my lords, my submission is, no possession was given.
No, what we have to do is, what is that you have styled it that as a document? What are the contents of it that has to be looked into? By you, whether you call it an affidavit, whether you call it and whatever it is, what is the sum and substance of that document have to be seen.
My lord,
So by virtue of these now, according to you, you fall under E. Now this amendment is much after the,
very true, my lord.
yes.
It is not applicable to my case.
Hmm.
My document was in 2007.
Hmm.
Now, my lords, kindly turn to,
No, according to the court, which is applicable.
my lord, court applies 41E, my lord.
Let's read that.
Yes, my lord, that portion I will take. Kindly turn to, my lords, page 33 of my
No,
report.
let us read it. What did the court, what is
Lord,
what,
I
what
take-
41A says?
I take my lords to para 18, page 33.
No, book
Therefore-
is here.
Yes,
We'll read the provision.
provision will read, lords.
Yes.
Provision, sorry, my lords, I skipped a last portion. I will. Article 41.
Hmm.
Lord, 41 was inserted, as your lordships have pointed out, 1/4/2009.
Hmm.
When given for consideration and when coupled with interest and authorizing the authority to sell any immovable property. My lord, the word used is sell. Kindly go to my lords 41EA, that is next clause. If relating to construction of a or development of immovable property, including a multi-unit or multi-storied house or building, or an apartment or flat or portion of it, executed by between owner or leasing, as the case may be, and developer, having a stipulation, whether express or implied, that in consideration of the owner or lessee, conveying or transferring or disposing of in any way the undivided share or portion of land or immovable property, the developer agrees to convey or transfer or dispose of in any way the proportionate or agreed share or portion of the constructed or developed building or immovable property to the owner or lessee, as the case may be. But now what is stamp duty payable is mentioned on the right side. My lords may kindly see 2 rupees for
Has
every
applied Article 21.
article
Court
21.
has applied Article 21.
21 I
We
will
have to look at 21.
21.
Yes.
Conveyance.
Why it is not applicable?
Article 21,
Yes.
an extract, copy of extract. Notes.
Hmm.
Clever.
Please read.
I will read Article 21 notes. Article 21.
No, for that, we'll do, so first let us read section 2D.
Section 2D I will read notes.
Hmm.
Two D,
Section two D,
please.
conveyance includes,
Section conveyance includes the conveyance on sale, every instrument, every decree or final order of any civil court, every order made by High Court under Section 394 of the Companies Act in respect of amalgamation of companies, by which the property, whether movable or immovable, or any estate is transferred to or vested in any other person, and which is not otherwise specifically provided by the schedule. Now, the document, whether it amounts to contract or not, is yet to be interpreted, constructed by the trial court. Now, we are at the stage of, my lords, evidence stage.
no, it is not about, if it is a, it's not a, that is a stamp duty, if it is not impounded, then your question of going into the trial would not arise unless and until the document is marked. So that this is the stage where it has to be decided.
Very true. My lord, this, I hope, my lords, 41 EA, which I have read. My lords, now section 2 deals with the conveyance, my lords, which I have read. Where the immovable property is transferred or vested in or any other person, or which is not otherwise specifically provided by the schedule. Now, they say same duty as conveyance in the case of sale or transfer.
Please come to 2021,
Please. Section 21, my lord.
21 to 22.
My lord's article or section?
Article,
Pardon me.
article. No,
Please.
how this will fall under 21?
My lord, since it is a conveyance, my lord, the affidavit from looking into the affidavit and the power of attorney.
No,
My lord, yeah,
no, we'll go
I
to,
will say,
no,
Lord,
I
so
want
far
to
as
know
my
from
lord-
you. Please come to D, the definition 2D.
Conveyance, sir.
Yes.
Conveyance includes a conveyance on sale, every instrument, every decree or final order of any civil court, every order made by High Court under Section 394 of Companies Act, by which property, whether movable or immovable or any estate is transferred to or vested in or any other person, and which is not otherwise specifically provided for by the schedule. My lord, what happened, my lord, in the instant case, the entire claim is based
Please
on,
use the mic.
my lord, here in the instant case, the entire claim of the plaintiff is based on unregistered, my lord, the notarized affidavit and unregistered power of attorney. My lord, from looking into the affidavit is concerned, para 7 of the affidavit is looked into. There is a reference regarding the execution of the unregistered power of attorney in favor of the plaintiff. And from clause 9 of the affidavit is looked into. The powers granted under the affidavit is that, my lord, the
Mortgage, you can do
yes,
all.
mortgage, create charge, mortgage, and assign the scheduled property with any bank or financial institution for raising any loans or advances towards development of the scheduled property. My lord, in the similar circumstance,
Except sale,
yes,
everything is
yes,
given.
he can. My lord, in the similar circumstances, this honorable court has held, where also, my lord, the suit for specific performance based on the unregistered affidavit and power of attorney. And agreement is of the year 1995 and the power of attorney is followed by the agreement 1997, the power of attorney. This honorable court, my lord, by applying the article 21 and also 41E, my lord, the directed to whatever the order, the impounding the document under 33 and 34 of the Stamp Act is taken into impound the document. And my lord, the confirms the order passed by the trial court. I mean, permitted to pass on this. This is also similar set of facts, my lord.
No citation we can do.
Which is relied on, which is.
Yes,
cited
my
in-
lord. Head note, my lord, the Article 41E. Here also, my lord, the agreement is of the year 1995, followed by power of attorney 1997, and the impugned order passed by this honorable court in the year 2014. The power of attorney.
Let's just read from the beginning. What are the facts?
The petitioner has preferred this writ petition challenging the order passed by the trial court impounding the power of attorney, which was sought to be marked by the plaintiff and directed him to pay the duty and penalty. The plaintiff has filed the suit for specific performance of the agreement of sale against the defendant. The defendants are contesting the suit. Issues are framed. The plaintiff, during the course of evidence, has produced the agreement of sale, which is marked as Exhibit P1. He sought to produce the power of attorney executed by the defendants in favor of his brother Sunil Batra. It shows that not only the agreement is executed, but it is also acted upon. At this stage, the defendant objected to marking of the power of attorney on the ground that it is required to be stamped as conveyancer in terms of Article 41 of the Karnataka Stamp Act 1957, but insufficiently stamped. It is contended by the plaintiff before the trial court that the power of attorney, since it is not executed for consideration, it need not be stated as a conveyancer. The trial court, after considering the rival contentions and looking into the document produced by the case, concluded that the agreement of sale, power of attorney, affidavit, and confirmation deed receipts are all simultaneously been executed. All these documents have been construed as a contemporaneous transactions. Thus, the power of attorney is executed for consideration and it is insufficiently stamped. The exercising the power under the section 33 and 34 of the Karnataka Stamp Act, the trial court has impounded the document, directed the plaintiff to pay the stamp duty of rupees so and so. And next para, my lord. So and so, he is appearing for the petitioner contended that Article 41 is attracted only when the power of attorney is executed for consideration and authorizing the attorney to sell the immovable property. In this case also, power of attorney, sale of immovable property, it is not for consideration, and therefore the order passed by the trial court treating the power of attorney as an insufficiently stamped document and impounding the same is erroneous. And yes,
Para 7.
yes,
Para
yes,
7.
para 7.
Therefore, in order to attract payment of stamp
Yes,
duty
ma'am.
under the above article,
the power of
have to be
attorney
executed for consideration.
consideration.
It should authorize the
Authorize the
attorney to sell the immovable
immovable
property. Two
property.
conditions have to be fulfilled. Now you are saying that it is for consideration. There is no doubt about it.
Yes,
Then it do not authorize him to sell any property.
but my lord, based on the power of attorney, my lord, the certain rights has been given to the plaintiffs. In this aspect has been discussed by the trial court, my lord, also while passing the orders, my lord. I would
So,
like to,
As far as this is concerned, the learned judge has taken two things into consideration.
once for
Consider-
consideration.
It has
Yes,
to be that there should be a consideration and there should be a right to sell the property.
yes.
In
So
that,
far,
admittedly, it is not there. in
so
this-
far as my lord, for consideration, my lord, it has been reflected in the power of attorney for a sum of rupees 67 lakhs. So far as my lord, it should authorize the attorney to sell the immovable property. The same will attract, my lord, the clause 9 of the power of attorney. I would like to take my lord attention to
Clause
clause
9,
9.
page number.
86 minutes.
86.
Yes.
To create, charge, mortgage, and assign the scheduled property with any bank or financial institution for raising any loan or advances towards the development of the scheduled property.
That's what the first question I asked him. What is this mortgage? If you do not have any powers on that, on the said property, how can you mortgage? So by virtue of this power of attorney, when that powers are given to you, and now when you have a power to mortgage those properties, you just can't say that it is a simple understanding or a GPA.
It is an irrevocable power of attorney.
That to irrevocable power of attorney.
My lord, there are two more questions will arise for consideration to your lordships. Your lordship may have to deal with that. Number one, whether the stamp duty is payable on these documents, whether the determination by the trial court is correct or not.
My lord, so far as the
My lord, may I complete? Let him.
just a minute. If there is a wrong in calculation by the trial court, my lord, it is open for the plaintiff, my lord, to approach the trial court.
Once the particular provision applies, if you say that the calculation is bad, that can be looked into.
My lord, my alternative submission is twofold, my lords. My attack on this impugned order is twofold. One is, my lords, the word used under section Article 41E, your lordships are carefully, I have read it. The careful consideration of the provision, the word used is to sell. Your lordships are aware. But in this power of attorney, only to mortgage and lease. to create third party right, to alienate the property is not there. The learned judge commits an error saying that attributes power to sell by misreading this power of attorney. Whether it is there or not, your lordships are now examining the correctness of the impugned order.
In the order, it said that it can be sold.
Yes, my lords, in the impugned order,
No, it is not, my lord.
Para? Which para he said so? The general power of attorney dated produced by the plaintiff request duty. Yes, 41E is.
as conveys, your lordship, my lords, entire para may I read, my lords. Therefore, the general power of attorney dated 31/12/2007, produced by the plaintiff request duty as conveyance under Article 20, subclause 1 of the Karnataka Stamp Act 1957. In view of the above said ruling, the plaintiff has to pay stamp duty.
Power of attorney dated 13/12/2007, there is a clear recital that the same is coupled with interest. Where is it?
Apart from this coupled with interest, kindly go through, my lord, the para made in the plaint itself, averments. His claim is based on the power of attorney. Based on the power of attorney, my lord, he sought for, my lord, directed the defendant to execute the joint development agreement. In page number 45, his prayer, my lord, kindly looked into. In page number 45.
45.
45.
Hmm. Hmm.
Prayer A, specific performance of an agreement dated 31/12/2007, directing the defendant to facilitate / not to hinder the conversion of the said property from the agricultural to commercial use by the plaintiff herein. And upon such conversion, direct the defendant to execute the joint development agreement in favor of the plaintiff in terms of the agreement dated 31/12/2007 and abide by the same. My lord, the agreement is coupled with interest. That is the power of attorney. And apart from that, my lord, the clause, in view of the clause 9 of the, my lord, the power of attorney, my lord, the power of attorney, my lord, it is attract, my lord, the section 41E. He ought to have paid the duty penalty on the market value by, my lord, followed by Article 20A, my lord, or 21.
May I submit, my lords? To narrow down the controversy, my lords, your lordships have understood now the crux of the issue. Your lordship may kindly turn to my lords, what is the stamp duty payable? If at all stamp duty is payable or not? If at all stamp duty is payable, by whom it is payable, and what is the amount payable? That's all the questions before lordships for consideration.
No. First of all, which provision of which article applies? Is the first question.
Please, my lords.
Whether there is any conveyance is there or not is the first question. Now, as far as that is concerned, your prayer itself speaks about it. Your prayer in your plaint.
Prayer in the plaint, my lords.
What you're seeking.
My lord,
and
no.
what are the terms and conditions of that?
My lords may kindly turn to my lord the affidavit. Next document.
Yes.
Kindly turn to my lords page number.
No, it is an irrevocable general power of attorney.
My lord,
You are permitted to do so and so acts. It is coupled with interest. So in so many words, it is not stated. You are empowered to do everything.
My lords, in the power of attorney, what you are saying is consideration is shown. It is not shown. In the affidavit, it is shown.
Now, both of them
To be
are
read,
executed on the same day. And for the purpose of evading stamp duty and other things, if you have two documents, both of them can't be read in. Now, you're relying on two documents. Basing on those two independent documents, you seek a relief of specific performance. You seek other relief of that joint agreement, something that development agreement and all you speak about. When it comes to stamp duty, for the purpose of your prayer, you want those two documents to be read together. And for paying the stamp duty, both of them have to be looked independently. By virtue of that consideration that is passed to the defendants, this agreement on the same day is entered. And unless and until you pay the 65 lakhs, why would they execute that agreement in your favor? So we can't consider those two documents independently and cannot say that because there is no consideration, it can't fall under 21.
My lord, my learned friend made a submission saying that to avoid stamp duty, this is done. My lords, stamp duty is payable, my lord, this court will decide. Ultimately, it will be binding on the parties. But such circumstances, my lords, in those, my lords, Karnataka Land Reforms Act, the company could not enter into a joint development agreement unless the land is converted. It is for that purpose and to safeguard my payment, which is made. These two documents have come into existence. Because I am one of the parties to the agreement, that the person who is the owner of the land is no more. My lords, from my side, my lords, in order to, my lords, facilitate and safeguard my money, it is not necessary that only to avoid stamp duty. Now kindly turn to the logic of the learned trial court. It says, my lords, 41E, the court passes an order which is not even applicable, the provision, the schedule. This court will definitely say which is applicable. I am not finding fault with that. But the manner in which it is decided, my lords, is 34. Kindly see how much is payable. Now, my lords, even if it is payable without prejudice to my right to contend that these documents do not amount to conveyance as opined by the learned trial judge, my submission is kindly turn to my lords. What is the amount of stamp duty determined by the trial court? Trial court doesn't take the help of revenue authorities. It doesn't take the help of deputy commissioner.
Ask them to do, we'll ask them to do on an application by
Only
you.
one nimisha.
Similar
Let me,
question
my lord,
has been
complete.
put in the previous court also, my lord. Then court insisted, what are the procedure to be followed, my lord, for determining the undervaluation? And court insisted me to, my lord, the furnish this.
No, that the lower court will take care of it. We'll direct the
That
lower
right is
court.
there, my lord.
All those issues will not decide here. No, we'll only decide as per which provision will apply and how it is, now whatever evidence you want to adduce or whatever help you want to take and whatever procedure to be followed, let it be followed.
My lord,
Further, that is not the headache of this court.
my lord, without holding any inquiry, this, my lords, kindly turn to page 34.
If
41 lakhs, my lords. According to me, it will be less than 4 lakhs.
Council.
Please.
Now, first of all, we will determine which section would apply. Once a particular section applies, if according to you, that calculation that is arrived at by the court is not right, then move the court. Will give you that liberty as far as the calculation is concerned. But will affirm the order of the court as far as which article of the act applies to your case. It comes under conveyance and we'll hold that.
My lord, the government has the say in this matter, my lord. You lordship may treat this as partner. Let the government also file.
No, government, no, this is not, this is a suit between you and the defendant. Now, whatever you want to do it. Now, why a 2018 writ petition be pending here for this purpose?
My lord,
This court is, this is not all this exercise, it's not, this court is not supposed to do all that.
your can you take one judgment of this court?
Yes.
Where this honorable court said it should be sent to revenue authorities. That is where the illegality arises. So this is the case where, my lords, 2020, my lords, judgment of Karnataka High Court, where this honorable court held that the revenue authorities' assistance has to be taken for arriving. My lords, my submission is without holding any inquiry, my lord, this impugned order is passed. To put in one sentence. Kindly
So
turn-
you are relying on some judgment, what is it?
I will read, my lord. This is,
No, 1 minute, he passed on something.
yes,
This is open as
Please.
judgment.
Yes, my lord. That
Ah.
is the, my lord, the procedure to be followed, my lord, while determining the stamp duty.
Hmm.
Once, my lord, the court held that, my lord, the section provision of the Article 41E is attracted. Then what is next, my lord? In the previous.
Where is
judgment,
that? Which para?
Previous,
Judgment you're relying on 2015-6 Karnataka Law General.
so far as, my lord, previously, my lord, I cited 2014 Part 3
Hmm,
cases here, my
hmm,
lord,
hmm,
in which, my lord, the court observes.
hmm. Yes.
Illi relevant portion, my lord, in this relevant portion of the order, para 2, clause 2. However, it is for any error in the rate of stamp duty payable on the power of attorney as calculated by the trial court, it is open for the plaintiff to point out the same same to the trial court. That court observes.
That is what precisely I'm
Yes.
saying that we will.
Yes, my
observe
lord.
now.
And the since, my lord, my learned friend has argued the subject matter of the land is an agricultural land, the same is not attracted, the provision of the 41, Article 41 is not attracted. Then court insisted me to furnish this judgment, my lord. This is the procedure to be followed, my lord, how the stamp duty has to be calculated.
Para number.
My lord, the relevant portion, my lord, I would like to take my lord attention to, my lord, the para 5 onwards. In the light of the above outset, it would be necessary to take note that order passed by the appellate authority, it is no doubt true.
Where are you
Uh,
reading? Which
My lord,
judgment?
the next judgment, my lord, the 2015 Part 5 KLJ 379,
No, no, no.
Bopanas judgment,
That is not 379 what you gave to the court. It is
2015 Part 5 KLJ.
2015-6 Karnataka Law General 127. That's what you have given.
This one, my lord.
Nitin Kumar. Party's name Nitin Kumar.
Kumar, idu. This one, my lord.
Give them. No, you've given some other judge.
Oh, sorry, my lord. This one.
You have only one copy.
One.
Which
That-
para you said?
Para 5 onwards, my lord.
In the light of the above, it would be necessary to take note of the order passed by the appellate authority. A reference has been made therein stating that the original authority at the time of inspection has found that the property was being purposed, and without disclosing this fact, the valuation of for the property has been made and the stamp duty has been paid accordingly. Even for the reasons so the same does not satisfy the what is the ratio laid down in
My
the?
lord, so far as my lord, regarding
No
ca-
ratio in that.
procedure to be, what is the procedure to be followed, my lord, will determine. The revenue authority has to inspect, and when proviso of the article 41 is made attracted, then how to calculate the stamp duty, my lord?
No,
Yes.
no. Once this particular article applies, that says on market
Market
value. of
value,
so and
yes,
so.
Yes, yes.
For that, what is the procedure? That is the, as per the book value, whatever you call
Yes,
it here,
yes,
I don't know, that should be placed before the
Under
court.
value, yes.
And basing on the book
sub-register
value, if
value,
it is
sub
an
value.
agriculture property, agriculture as per that. If it is a non-agriculture, non-agriculture.
Please, my lord,
What
that's,
is required? There is no other procedure for that.
yes, ma'am.
There is one more point, my lord, I would
Yes.
like to kindly just turn to my lord, section 33 of Karnataka Stamp Act, 33, 34, my lord.
Yes,
Those two provisions are applicable for the facts of this case.
1 minute, 33.
Impounding, my lord.
Yes, 1
Ma-
minute.
Please.
Let me open that.
May I read, my lord, 33?
Please read.
Examination and impounding of instruments. Every person having by law or consent of the parties authority to receive evidence, and every person in charge of a public office, except an officer of police, before whom any instrument or chargeable, in his opinion, with duty is produced or comes in the performance of his functions, shall, if it appears to him that such instrument is not duly stamped, impound the same. For that purpose, every such person shall examine every instrument so chargeable and so produced or coming before him, in order to ascertain whether it is stamped with a stamp of the value and description required by law in force in the state of Karnataka when such instrument was executed or first executed.
What
Provided,
purpose you are relying on this?
my lord, this has to be read along with section 28, my lord, by whom it is payable. He is the landowner of the property, I am the power of attorney holder. He is the principal, I am the agent, my lord. The law says that principal should pay. That is the correct position of law.
Let him come to the court, then you don't come.
My lords, no, by law, this is the primary obligation is on the owner of the property.
Then I'll
And
record
that
that.
is my alternative submission, my lords. I wanted to bring it to the honorable court. Not that I am running away from this document has to be marked.
Please, before making such a submission, no, if a document to be admissible in evidence,
I have to,
it
my lords.
has to be a properly stamped
Please,
and a registered document.
please.
No, you come to the court and you say that it has to be, the stamp duty has to be paid by the defendant. How does it make
My lord, I
any?
am not saying that is what law says.
Law says,
Please,
but
please.
okay, don't rely on that. Don't rely on that and don't seek a prayer on that.
That is the only document, my lord, with black and white.
That's what.
It is like a jacket on the drowning person.
No, that we have seen. Now there, as far as that, say, Article 21 applies, this court is of the view that it applies. Now, this next question that comes is about determination of the market value. For that determination, let you come up with an appropriate application before the court by getting the property register, whatever the value as per the registrar's
Guidance
office
value.
placed before it, it will be determined.
Please.
come.
That's all.
Yes. The present petition is filed. Agreed with the order passed in number 9 in OS number 9 of 2011 dated 31/8/2018. The plaintiff
My lord, may I intervene? Sorry. Kindly see the cause list. High Court cause list. it says that the earlier order is abated and all. Everything was set right, my lords. We have filed application for abatement, that may be corrected.
Then that abatement is set aside.
Set aside and LRs were brought on record. I made a correction in the,
31,
in the writ petition,
what is that?
filed amended writ petition.
The plaintiff is before this court. The plaintiff had filed a suit for specific performance and also sought the relief of sought for specific performance of an agreement dated 31/12/2007 and seeking a direction to the defendant to execute a joint development agreement in favor of in terms of the agreement dated 31/12/2007 and abide by the same. And also a mandatory injunction restraining the defendant from cancelling, revoking the irrevocable general power of attorney dated 31/12/2007, along with other prayers. In the suit, the defendant had taken an objection that the defendant had taken an objection and has come up by way of this IA number 9, stating that the affidavit and the general power of attorney dated 31/12/2007 is insufficiently stamped and the same has to be impounded. It is a specific case of the defendant that the plaintiff has filed a suit for the relief of specific performance of agreement by way of affidavit based on the unregistered general power of attorney and affidavit dated 31/12/2007. It is a case of the defendant that in the notarized affidavit, payment of consideration of 67 lakhs has been shown, stating that the said amount has been paid to the defendant by the plaintiff firm. The general power of attorney refers to the affidavit in para number 7. According to him, both the documents are according to the defendant, both the documents are contemporaneous to each other. Further, clause 9 of the general power of attorney would attract duty and penalty. Therefore, plaintiff is liable to pay duty and penalty on the consideration shown in the affidavit dated 31/12/2007. To that, the plaintiff has filed his objection stating that matter is at the stage of evidence only for the purpose of tracking the proceedings. The present application is filed and the same is liable to be rejected. The notarized general power of attorney dated 31/12/2007 and the affidavit dated 31/12/2007 are duly stamped and are in accordance with law. And the stamp duty is paid in accordance with the Karnataka Stamp Act. And certain other allegations are made that the defendant is not abiding by the orders of the court. The court below, the trial court had considered the contentions raised on behalf of both the parties and allowed this application, holding that the general power of attorney dated 31/12/2007 requires duty as conveyance under Article 21 of the Karnataka Stamp Act. And he has to pay a proper stamp duty as per section 41E of the Karnataka Stamp Act. And for the stamp duty, for the proper stamp duty, the deficit stamp duty, and the penalty was calculated, and the plaintiff was directed to pay an amount of rupees 41,24,780, towards the stamp duty and for impounding the same. Aggrieved thereby, the plaintiff is before this court. Learned counsel has raised the contentions. The specific contention of the learned counsel for the petitioner submits that is that there is no consideration under the general power of attorney dated 31/12/2007. The general power of attorney do not give right to the plaintiff to sell the property. There is no possession given to the plaintiff. As there is no, as such, it do not amount to conveyance as defined under section 2D of the Karnataka Stamp Act. And as per section 21, as per article Article 21 of the Karnataka Stamp Act. Further, it is submitted that even the manner in which the said amount is determined by the court is also not correct. And an improper calculation was done by the court without seeking any assistance from the revenue department. It is submitted that at any stretch of imagination, the section Article 21 do not apply to the present case and to these documents, as they cannot be called as conveyance. Next one. Learned counsel appearing for the respondent submits that respondent defendant court officer outside the court, what is happening? Tell where is the attender? Ask him to tell. It is a case of the respondent defendant. That the general power of attorney gives the authority to the plaintiff to mortgage and do several acts. Further, it is stated that it is a irrevocable power of attorney and coupled with interest. All these clearly shows the intention of the parties and the rights that are accrued to the defendant, that are accrued to the plaintiff. It is submitted that the court had rightly considered the same and also applying the ratio in the judgment in case of Mr. Suresh Bhatia versus Srimati Gullama and others, reported in 2014 3 cases CR 2773. The court had rightly held that Article 21E applies to the Article 21(1) applies to the facts of this case. It is submitted that if it is a case of the plaintiff that the amount that is calculated by the court while applying Article 21 is not correct, it is always open to him to come up with an appropriate application before the court. He submits that both the arguments that are advanced by the petitioner runs contrary to the other. It is submitted that the court had rightly held that it is conveyance and the stamp duty needs to be paid. As Article 21 applies, they have to pay the stamp duty. Next, heard the learned counsel for the petitioner of counsels on either side and peruse the material on the part. The suit is filed for specific performance and also several other reliefs there. And in that, the main relief is, apart from specific performance, directing the defendant to execute a joint development agreement in favor of the plaintiff in terms of the agreement dated 31/12/2007. It is as per the affidavit, as per the agreement, an affidavit is found. And as per that, the plaintiff had paid an amount of rupees 65 lakhs,
67 lakhs.
67 lakhs to the defendant. Thereafter, a general power of attorney is executed. Now, the general power of attorney gives so many powers to it is an unregistered general power of attorney, which, by which the plaintiff can create, charge, mortgage, assign the scheduled property with any bank or financial institution for raising any loans or advances towards development of scheduled property. Further, the said general power as per clause number 7 of the agreement, the authority granted shall be irrevocable in as much as the same are coupled with interest, such interest being the development of bare shell of commercial building on the scheduled property by the developer. A combined reading of both the affidavit and the GPA, which are dated 30 dated 31st December 2009, 2007, reveals the intention of the parties. Though it is not stated that the general power of attorney, you do not give the power to the plaintiff to sell the property. But the other condition, the other clauses and a complete reading of the GPA and coupled with the affidavit where 67 lakhs consideration is passed clearly shows the intention of the parties. Whatever way the document is styled as, but the court has to look at the document and what are the rights that are passed through said document. In the considered opinion of this court, in the light of the law laid down by this court in Suresh Bhatia's case, the trial court had rightly held that as per the Article 21(1) applies to this case, and the stamp duty has to be paid. Now, the second submission of the learned counsel for the plaintiff that the calculation that has been made by the court is wrong and no procedure is adopted to that. If it is for the plaintiff to say that this is an agriculture or non-agriculture property, and as per the registered maintained by the registration department, these are this is the stamp duty and the registration charges, and accordingly the court will determine the same. As it is the contention of the learned counsel that the said procedure is not adopted, and just like that, the court has calculated and arrived at an amount which is not correct. This court deems it appropriate to direct the court below to do the said exercise accordingly. The following, the order as far as the applying of the applicability of Article 21 is concerned, the same is upheld. Then coming to the determination of market value and the calculation that is made is set aside. And the petitioner plaintiff shall come up with the relevant documents pertaining to the stamp duty as fixed by the stamp duty as fixed, stamp duty as per the property, as per the registered maintained by the registration department. Basing on that, the code below shall calculate the stamp duty and the penalty that has to be paid. Third, this is a suit of 2011. The same shall be disposed of by the court below within 6 months, as expeditiously as possible, but not later than 6 months. That the court shall not grant any adjournments for determination of the next point, for determination of this exercise, or determination of the stamp duty and penalty. The entire exercise shall be completed within within 1 month from the date of receipt of copy of this order. Disposed.
Lord, appearing for petitioner counsel,
Yes.
Lord, the petitioner's father, Krishnappa, had purchased a family property, it's an undivided share from one of the sharer of the family. It's under a registered sale deed. Then, my lord, the partition suit was filed without impleading us. Then suit came to be decreed. Then, my lord,
You are also a member of the joint family.
I'm not a member of the family, I'm the
But there is
purchaser.
a undivided share.
Yes, I'm the purchaser of undivided interest of two sharers of
Purchase, purchase, when is the purchase?
1990, my lord, I have purchased. I have produced the sale deed.
Hmm.
Lordship may kindly say I purchased the
The
property.
suit,
Bigger lordship.
suit. When is the
Suit
suit?
is, my lord, 89, 74 of 1989,
74 of,
1989.
you, pending suit you have purchased.
Yes, yeah, of course. Purchase in, during pendency of the suit I purchased.
Yes.
Let the partition suit, it makes no difference.
So suit
Because I'm entitled for share of my vendor, that's all.
is decreed.
Yes, suit is decreed.
When?
Then, my lord, the suit was decreed on, my lord, the 1989 it was decreed.
Same year it is decreed.
Yes, 1989 it was decreed.
So
Then-
even as on the day the decree is passed, that day also you have not purchased. the
I was not there. Then, my lord, FDP was filed in 1994, FDP 8 of 1994, 1994. My sale deed was 3/5/1990. Then, my lord, when the FDP was pending, I came to this honorable court in second appeal, challenging the judgment passed by the trial court in both preliminary decrees are concerned. This honorable court, my lord, upon examining the matter, passed an order. Your lordship will see that order, my lord, I have produced at page 32, annexure C, my lord, in second appeal. My father Krishnappa was before this court.
Page 32.
32, annexure C. May kindly go to page 33, my lord. The present appeal is filed against the preliminary decree passed by the partition in a partition suit. Appellant is an alignee during pendency of the suit. Appellant is placed ex parte in the suit. However, the final decree proceeding, the appellant was participated.
So
It
what
is
is
said-
this appellant is placed ex parte in the suit? What is that? First line it says appellant is an alien during. the
Laini,
pen-
the- anyhow, that we will, that fact may not be so relevant.
No, no,
What
when
is
you
the
have
relevant
partic-
fact is, this honorable court granted me a liberty to challenge the final decree if it is passed. That was the second appeal observation. They wanted to encash that, that's all. The appellant has participated. it is said that final decree is drawn up. As aligning is inappropriate for the appellant to work out his remedy for equitable partition seeking allotment of vendors'
So
share.
a party who has not questioned a preliminary decree, can you pass a final decree?
That-
Can
that-
you question a
that-
final decree?
Why my submission would be, there would be a, that is an arguable point, no pending in many matters before your lordships. A preliminary decree is a decree passed by the court declaring entitlement of the shareholders only, which is nothing to do with the purchaser or somebody third parties are concerned. If there is a unsatisfaction by any person in the family about a share and other thing, they could challenge an appeal before the regular appeal under section 96, then before this honorable court in second appeal. So far as a purchaser is concerned, that restriction provided under section 97 of CPC would not be applicable is an argument we wanted to address. To that extent, some matters are entertained which are pending before you
No,
this
no,
honorable.
on a academic, this thing.
Yes,
Now, whatever is a preliminary decree, in a
Correct.
final decree, it would be executed looking at
correct,
other.
correct, correct,
So,
correct.
in a final decree, court would not be deciding the entitlement of the parties.
No, I'm not
Court
asking
would
for,
only
nobody
decide
is, nobody.
That's what.
No, no,
By virtue of this, the
so
court has
far
to-
as the share determined in the preliminary decree, so far as my vendors are also concerned, there is no dispute at all.
No,
Correct.
whether such a, no, for example, you have purchased the property from A. Now A has two sons or whatever or the legal heirs. They say that particular sale, what has been done by A is not in the joint family interest or not for the joint family necessities. So such a sale is not binding on.
That is a different aspect of the matter.
Unless and until
That could be adjudicated by the civil court, that will be adjudicated if such a situation arises. Not, that could not be also decided in FDP. Suppose a decree, yes, he has to file a suit, the decree is not binding or sale deed is void. All those things open for another family member whose right is under prejudiced. He have a right to that. I am not on that point.
What I want to know is, in this, whether the sale deed, whether the sale transaction that is entered into between you and one of the co-partners, unless and until court says that is so and so, and such a finding is not given, in execution proceedings, what is the execution court to be do?
Madam,
to
my
have to-
submission is, we were before the FDP proceedings. There's a judgment of the Supreme Court says, in FDP proceedings, in addition to the other issues, which is consequential incidentally coming up before the FDP court is empowered to adjudicate that.
There are certain section
Yes,
47
certain
and
contingencies
other,
are. For
contingencies.
example, I would like to put it in this way. My lord, my vendor have got a share of 1/3 share in the property. I have purchased the entire property belonging to the family. Now, my lord, I was not made as a party, or I was made as a party in the suit. It is a different aspect. In a final decree proceedings, my lord, if I am not made as a party, if I go and tell the court that my vendor have got 1/3 share as determined by the civil court, I am entitled for that while affecting equitable partition by the FDP court. That is the main function of the court is concerned. In that way, it would not given a room that a final decree court may deviate from the preliminary, that question would not arise.
Do you have a citation which says any?
Yes, my lord, I extracted the citation, may kindly go to page, my lord,
A citation which-
2009 9 SCC.
Citation which says that a party who has purchased a property subsequent to the partition decree, preliminary decree, and who has not questioned such a decree or who has not pleaded himself, his rights can be determined in a final decree proceedings. Where
My
is
lord,
that
now
text?
my submission is, 2009 judgment.
Yes.
In one copy. My lord, 2009 9 SCC page 689.
Please pass on.
It's a reference of section 2 subsection 2 decree 33, 54, Order 20, Rule 18, 18, 1 and 2, Order 26, Rule 13, 34, and so many part, and including Section 3524 of Partition Act is also referred. My lord, may kindly see it. In a suit for partition or a separate and half a share, the court at the first instance decide whether the plaintiff has a share in the suit property, he is entitled to division and separate possession. The decision on these two issues is exercise of a judicial function and results in first stage decision termed as a decree under Order 20 Rule 18.1, termed as a preliminary decree under Order 20 Rule 18.2 of CPC. Consequential division by metes and bounds, considered to be a ministerial or administrative act, requiring the physical inspection, may kindly, my lord, instances, physical inspection, measurement, calculations, considering the various permutations, combinations, alternates of division, is referred to the collector under Rule 18.1. It's a subject matter of the final decree under Rule 18.2. My lord, while exercising this power, what the things to be bear in mind of the court, FDP court, is it should not deviate from the decree, which is a preliminary decree is concerned. Suppose my vendor is entitled for 1/4 share. If I purchase the larger extent of the property, while making this adjustment by the final decree court, they can allot me a 1/4 share of my vendor. This adjustment is permissible.
From this, which para?
Which matter paragraph, your lordships may kindly see that paras at para 15 and 21.
Yes. Please read that.
Just I would like to take your lordships to para 10 at page 694.
Yes.
The term preliminary decree, final decree used in the said rule, defined in explanation to section 2, subsection 2 of the CPC. Explanation: a decree is a preliminary decree where further proceedings have to be taken before the suit can completely dispose of. It is a final when such adjudication completely disposes of the suit. It may be partly preliminary or partly final. Then section 54 of the code defines partition of an estate separate share, where the decree is for partition of an undivided estate, assessed to the payment of revenue to the government, for the purpose separate possession of a share of such an estate. The partition of the estate or separation of the share shall be made by the collector and then guested subordinate or collector deputed by him in this behalf, in accordance with law, for the time being in force, etc., etc. Then your lordship may kindly go to page 15, para 15 minute. It is thus clear that every application which seeks to enforce a right or seeks a remedy or relief on the basis of any cause of action in civil court, unless otherwise provided, will be subject to the law of limitation. But where an application does not invoke the jurisdiction of the court to grant any fresh relief based on a new cause of action, but merely requests the court to do its duty by completing the remaining part of the pending suit, there is no question of any limitation. Such an application in a suit which is already pending, which contains no fresh new prior relief, is not one which the Limitation Act 1963 provides. These principles are evident, etc. Then go to paragraph 21.
Yes. Yes.
A preliminary decree for partition only identifies the properties to be subject to partition, defines and declares the share right of the parties. This part of the prior relating to actual division by metes and bounds, allotment is left for being completed under the final decree proceeding. Thus, the application for final decree, as and when made considered to be an application, is a pending suit for granting relief of division by metes and bounds. This is the law. Ultimately, we knocked the doors of final decree court. We said we have purchased some share of some of the family member. Their under the preliminary decree, their extent of share have been declared. Please allow us to participate in the proceedings. My lord, keeping us, when there is a decree for 1/7 share, final decree passed only allotting a share of only one sharer and without affecting the partition by meets and bounds of other 6 sharers are concerned. That's a stage, my lord. We, at thereafter, a execution petition was filed by the party who got a final decree in her favor to execute the decree for the purpose of dispossessing the persons who are in possession of their respective shares are concerned, alleging we are the encroachers of theirs as determined in the preliminary decree and final decree proceeding. When delivery warrant was issued, this petitioner, that my lord the purchaser, had approached this honorable court, knocked the doors of this honorable court for their indulgence. This honorable court granted interim order. At the latest stage, writ petition came to be disposed of, saying that since the time stipulated to execute the delivery warrant have been spent on its own, writ petition would not become survive. Therefore, if you have got any other remedy, you can go and appeal the FTP court. That was the observation made by this honorable. Taking advantage of that order, including the observations made by this honorable court in second appeal in earlier round of litigation, I went to the executive FDP court saying that, you see, there is a preliminary decree in which 7 shares have been divided into between 7 members. I am the purchaser from members A and B. Their share I am entitled to seek allotment in my favor, and they are also have no grievance whatsoever. That's all the things I went to the executing court, the FDP court. FDP court says, since I have already passed a final decree, I do not want to reopen it. This was the order passed by the FDP court. That order is not impugned in the present decree. In the, sure. I will tell you to take your seat. Then what happened was, then my lord, we challenged this order here when the writ petition is pending. Another purchaser of another share by the another family member have also filed an application before the FDP court to reopening of the FDP enabled to adjudicate his grievance. Now that application came to be allowed and FDP proceedings are revoked. Now FDP proceedings are pending. This is the intervening development which have taken place.
Where is that order?
That I wanted to. That's the reason I wanted to file a memo. This is the memo we wanted to.
Now after the final preliminary decree is passed, whoever comes before the final, before in the final decree proceedings, the court keeps on adjudicating which
It is
property
not
to
like
be,
that.
which property to be allotted to whom.
Not whoever he wants. A person
But
who
to a
claiming a right.
party who purchased the property in the
Yes.
year after the suit is decreed.
My submission is that's what I wanted to contend. So far as a partition suit is
Then
concerned,
claim it from your vendor. Why should the final decree proceedings be opened?
Milord,
No, you are entitled for a share from your vendor.
no,
You're
I will
entitled for
come
a share
to
from
that.
your
No,
vendor.
no. A separate suit to
Yes.
that extent would not be advisable. Would not be advisable. Anyhow, Milord, now I wanted a very small relief by this honorable court, taking note of intervening development. I filed a memo. May I read that memo for a moment?
Where is that order that it is reopened?
The entire order sheet.
No, there must be an order that there must be an application and an order.
Milord, on Geeta, Sujata and Pushpavati, they are the petitioners. They filed an application for reopening of the proceedings.
When it happened?
The proceedings is reopened at their instance.
Where is that? Where we get that? Some application is filed under section 47 of CPC.
Yes,
Why they have filed a 47 CPC petition?
they want share to be allotted to
And
them
that we will
towards
see.
of their vendor.
Yes.
I am not on that merit of the matter. Just look at me and hear me. Very small question I wanted to raise. I want a very small relief, though I am a senior counsel. I take it from me, my lord, in a lighter way I wanted to. Now, anyhow, it is not in dispute at the instance of some persons who are similarly situated with me. They made an application, FTP proceedings are revoked. So far as me is concerned, when I sought for similar relief, that was declined. Now I am neither here nor there. Therefore, a memo I have filed.
Under which provision of law a petition is filed by this petition?
Order 20 Rule 18 may not be made an application and read with section 151 of CPC. May I read the memo for that? May kindly be seen.
Yes.
It is submitted that the petitioner in this petition calling in question the legality and correctness of the order passed by the learned senior civil judge JMFC Sidlighatta dated 19/6/18 in miscellaneous 2 of 2018. Said miscellaneous petition 2 was filed under section 151 and read order 20 Rule 18, wherein sought for reopening of the FTP proceedings enabling to identify, demarcate share of his vendors who are the parties to the preliminary decree, where there are share also declared therein. The said miscellaneous application came to be rejected by the learned senior civil judge JMFC dated 19/6/2018. In the meantime, FTP was reopened at the instance of the application filed by some of the sharers, whose sharers have been declared under preliminary decree in OS 74 of 1989. Thereupon, the commissioner was appointed to demarcate the hands parties in their terms entitlement under preliminary decree. Commissioner appointed to that effect was conducted the survey, who submitted the report, wherein property purchased by vendors herein are identified in the name of vendor so-and-so, who are parties to so-and-so. Since the final decree proceedings are already been reopened and it is in progress, may kindly see next page.
Yes.
Progress, wherein the petitioner is also respondent number 7 therein, reserving liberty to the petitioner to work out remedy in the pending proceeding and check this writ petition may be disposed. That's only the small relief. I may get, I may not get, it's a different aspect. It's an adjudication to be made by the FTP court. They may say, no, sir, we will demarcate the share of your vendor. You can recover property from your vendor. I can follow that advice. No, we have not reached to that stage. My submission is, I am similarly situated other person. Where do we reopen the proceeding? In my case, you said no. Now I am neither here nor there. Give me a liberty. I will go and tell them this is the property I purchased. I am entitled for her share. It was the sale deed. You adjudicate it. That the court can say yes or no. If they say yes, I convey my thanks to the court. If they say no, I will come to this honorable court, knock the doors of your lordship. That's all the limited grievance I wanted to put. That is the reason this memo is filed.
Please come. Agreed with the orders passed in. Miscellaneous number 2 of 2018, whereby the court below, the trial court had dismissed.
One more judgment, can I?
Yes, please pass.
1991 3 SCC 647.
Please pass.
Yes. When final decree would comes to an end, suppose what it was happened in our case, there are 7 sharers are there. Final decree passed in respect of only 1 sharer. Other sharers are not known. The final decree have been drawn. No matter they are before the court, they are seeking allotment of their share. In that circumstances, what the Supreme Court said is, your lordship may kindly go to para 7. Head note may not may kindly be seen. Held on ideal.
Yes.
Page 648. A partition of the Hindu joint family can be affected by various modes by a family settlement. 648 will next page.
You are reading which para?
Held on the 648, page number 648. Just the next page to the head note.
Where is the para? We'll read the para.
That is not paragraph 8.
Para?
Para 8.
We'll go to that. Yes.
There are 7 million.
Yes.
There are 7.
Yes.
The question that falls to our consideration is, preliminary decree has the effect of depriving respondent number 2 to 5 of the benefits of amendment. Lieutenant Counsel placed reliance close so and so. And however, the legislature has conscious and prior to enforcement of amending act, partition will already have taken place in some families. Arrangement with regard to disposition of the properties would have then been made and marriage expenses would have been incurred. The legislature therefore did not want to unsettle the settled position. Hence it enacted providing the would not apply to the daughters of married prior to the partition of a partition, which have already been effected, etc. Thus, if the prior to the partition of the family property, a daughter had been married, she was disentitled to any share in the property. Similarly, if the partition had been effected before September 5, 1985, date on which the amending act came into force, daughter, even though unmarried, was not given a share. The crucial question, however, is to when partition can be said to have been effected for the purpose of amended provision. A partition of an Hindu, may kindly underline this below. A partition among the Hindu joint family can be effected by various modes, by a family settlement, registered instrument of partition, by oral arrangement by the parties, or a decree of the court. When a suit for partition is filed, in a court preliminary decree is passed, determine the shares of the members. Final decree follows thereafter, allotting specifies properties and directing partition of immovable properties by means and bounds. Unless and until final decree is passed and the allottees of the shares are put in possession of the respective property, partition is not complete. The preliminary decree which determines the share does not bring about a final partition. Pending final decree shares themselves liable to be varied, amount to intervening events. In the instant here, there is no dispute, etc. Ultimately, all the shares division to be affected by means and bounds. Then only final decree will be culminates. It's the last stage. That was the submission. That was the principle. I'm grateful.
What has happened? Yes. The High Court had dismissed the application filed under section 151 read with order 20 rule 18 CPC for reopening of the FDP number 08 of 1994. Aggrieved thereby, the applicant therein is before this court. The facts of the case are that the petitioner herein has purchased a property by way of a registered sale deed dated 3/5/1990 from the second respondent. First respondent had filed OS number 74 of 1989, seeking partition and separate possession of the suit property. The said suit came to be decreed on 15/4/1993. And further, Krishnappa, the purchaser of the property, Mr. Senior Counsel,
Sorry, one fact I wanted.
that is a crucial aspect.
Yes. 1990 I purchased.
You were set ex parte in the suit.
Suit was pending. 1993 I made an application for impleadment. Suit came to be decreed in 1993.
No. You were set ex parte is the first issue.
My father,
Whoever it is.
my father,
Whoever,
Yes.
your father is a person who has purchased. the
because I
property.
purchased the property in 1990.
Correct.
I inducted into judicial arena.
Then you were impleaded in the suit as a
Yes.
defendant.
Correct.
An ex parte decree was
Correct.
passed. Where is the ex parte decree question?
But for a decree or not, I challenged in RA as well as RSA.
Yes.
Both the courts said you have a remedy available to work out in the FD.
Yes,
That was the
The-
observation made.
yes. Purchase a set, the sale deed dated 3/5/1990. And second respondent is a vendor of the said Krishnappa and Lakshmana. That said, suit came to be decreed on 15/4/1993. The Krishnappa, the said Krishnappa and the purchaser of the property were placed ex parte, and decree was passed awarding 1/7 share each. Against that, Krishnappa filed appeal, RA number 28 of 1988, challenging the preliminary decree, and the said appeal came to be dismissed on 10/7/2001. Against the said judgment and decree, the said Krishnappa filed RSA number 735/2001 before this court, and the said appeal was dismissed on 1/8/2003 with the liberty to file an appeal against final decree. Now, after the final decree proceedings are initiated, the court passed a final decree on 12/7/2008 by determining and identifying the shares of the parties, one of the parties, and it has not determined or identified the share of these persons and erred in drawing the final decree without completing the process, and that is permissible under law. Unless and until such parties are identified and put them in position, final decree proceedings cannot be completed. And the order passed in the final decree proceedings is illegal, and the shares of the purchasers is not allotted to purchaser Krishnappa under the final decree proceeding. And it is an incomplete procedure, and it is not final in the eye of law. Now, these applications are filed by the legal representatives of deceased Krishnappa, and they have prayed the court for reopening of the order, for reopening of the FDP proceedings to adjudicate their rights as they have purchased 2 acres of land. The court below had considered the case of the applicants and about the earlier proceedings right from the day when the father of these applicants was set ex parte, thereafter the RA, then the RSA. And the contention that a liberty is given to them to question the final decree proceedings. The court observed that court passed a final decree on 12/7/2008 by determining and identifying the share of the not required, that is not required. The court has observed that the petitioners have filed this petition after 10 years of passing of the final decree. The petitioners have not explained the reasons in delay in filing this petition for reopening of FTP number 08 of 1994. And they have not even produced the final decree passed in FDP number 08 of 1994. The court has observed that this court cannot go beyond the order of the High Court, wherein in RSA number 735/2001, he was given a liberty to file an appeal against the final decree that neither Krishnappa nor his legal representatives filed appeal against the final decree. And they have filed this petition without challenging the final decree proceedings. As such, the same was dismissed. Next. When senior counsel appearing for the petitioner submits that when they have purchased the property from one of the co-partners and as they are entitled for the share that fell to the share of their vendor, when such is a limited exercise to be done by the court below ought to have reopened the FTB, the final decree proceedings, and ought to have considered the case of the petitioner as far as their share to the property, as far as their share in that, as far as the share of their vendor in the property purchased by them. the court below, without considering all this, on the ground that the FDP proceedings were closed, had dismissed the application. By way of a memo, they have placed before this court that the court had opened the FDP proceedings on an application filed by some other person, when it is their case that when their case was not considered, the parties are left remediless, and the court below erred in dismissing the application filed by the petitioner. The senior counsel had relied on the judgments of the apex court in case of Shubkaran Bubna alias Shubkaran Prasad Bubna versus Sita Saran Bubna and others, reported in 2009 SCC 689. Basing on the said judgment, then a senior counsel submits that the Honorable Apex Court has dealt with a preliminary decree and a final decree, and what are that has to be dealt with in a final decree. Further, with regard to the law of limitation, and he has also he had particularly relied on para number 21. Extract para 21 and 22. Then he had also relied on another judgment of the apex court in case of S. Sai Reddy versus S. Narayan Reddy and others, reported in 1991 3 SCC 647. He has relied on para number 7 of the said judgment, 7 and 8 of the said judgment, extract that. Basing on these judgments, learned counsel for the petitioner, so then senior counsel submits that the court below had failed to exercise the jurisdiction and also consider the scope of the final decree proceedings and also plight of a subsequent purchaser and about his share, and the order under revision is liable to be set aside. There is no representation on behalf of the respondent. This court, having heard the learned counsel for the senior counsel for the petitioner, had perused the entire material on record. The undisputed facts in this case are that OS number 74 of 1989 is filed seeking partition and separate position in respect of the suit scheduled properties. The father of these petitioners has purchased the property by way of a sale deed dated 3/5/1990 during the pendency of the suit from one of the co-owners of the property. Thereafter, he got himself impleaded in the suit. The court, as the matter was not contested, the court has set the father of the plaintiff ex parte, and an ex parte judgment and decree was passed on 15/4/1993. Thereafter, regular appeal was filed in the year of 1998 by the father of the petitioners herein, challenging the preliminary decree. That also came to be dismissed. Then on 10/7/2001, dismissed on 10/7/2001. Then they have filed RSA number 735 of 2001. By the time the final decree proceedings are already filed, the final decree is also passed in the year 1998. Then a liberty was given to question the final decree proceedings. And accordingly, the second appeal was also dismissed. This order of the court was on 1/8/2003. Now the present application came to be filed before the court on When was this application filed? Where is the application? Fourteen? 18. On 14/3/2018, the present application came to be filed under order 21. Or 20, filed under order 20 Rule 18 CPC for reopening the final decree proceedings. Is there any interim order in this? No interim. There. Hmm. When is that order passed? January 14th, what is the order? One minute. What did you write? 14? 14/3/18? Not 14/3/18, 14/3/18 only? 14/3/18. 14/3/18, the present application came to be filed. And the same was dismissed by the court by order impugned dated 19th June 2018. Thereafter, the petitioner has come up before this court, and on 14/1/2019, the court had passed an order of status quo with regard to the properties in question. The properties in question. No, it is their case that as the final decree proceedings are opened, the petitioner shall also be permitted to contest the matter. This case is a very classic example how the civil proceedings are being pursued by the litigants. When the suit is of the year 1989, property was purchased by the father of the petitioners in the year 1990. And when he was impleaded in the suit, when he was a party to the suit, then thereafter, they were set ex parte. When an ex parte decree was passed on, 19? One minute. 15/4/1993, an ex parte decree was passed. The vendor, the purchaser, that is the father of the petitioner, had kept quiet till 1998 without questioning it in an appeal. Then an order is passed in RA, that is on 2001 dismissing the same. Then an RSA was filed. That was dismissed on 1/8/2003. Even before that, the final decree proceedings where final decree was passed in the year of 1998. Then a liberty was given. Then from 2003 till 2018, nothing has been done. He has not moved his little finger. And what is that? Huh? When? No. Court has asked you to question the final decree. Where was it questioned? That is what I'm recording. That was not challenged. And in between. when a delivery warrant was issued, the same was questioned before this court and again obtained an interim order. And for 3 years, basing on that, the matter, there was an interim order before this court. Later, the parties, the same was disposed of, leaving it open to the parties to work out their remedies. Thereafter, the present present IA is filed. When there was an opportunity way back into 2001, 2003, to question the final decree proceedings that were passed in 1998, without doing it, the petitioner on one way or the other, questioning the proceedings, the ancillary proceedings, and coming up before this court. And in the other round, now he has come up before this court in the year 2019. Until now, the petitioner is, and then an order of status quo is passed by this court. This is nothing but a pure abuse of process of law. When the court has given him a liberty to question the final decree proceedings, wherein everything could be appreciated without a whisper about why he has not done all these years, has been questioning only with the process of seeing that the said final decree proceedings do not attain finality by obstructing whereby the decree that is passed by the court has just become a paper decree. One after the other, these kind of petitions filed shows the intention of the parties. And for these kind of litigation, this court, the abuse of, this is nothing but a pure abuse of process of the court. And these kind of petitions cannot be entertained by this court. Accordingly, the writ petition is dismissed with a cost of rupees 50,000. Yes, next matter. Yes. Yes, next. The final decree proceedings, if they are pending, still that's not the ground for this court to pass any order. And that too for a litigant who has failed to question a final decree proceedings, which an order is passed where this court has given a liberty. Yes. No. Yes. Yes. No, can't be. You are enjoying the status quo from 2019. No, that is not the law. Yes, next.
I paid the money to members.
Unfortunately, that is the impression of the court. You have a remedy. Yes. Yes.
That's what I said.
Yes, next, 4.
That 4,20,000 is pending. I am filing the memo of
Give
calculation.
that.
He has paid only 1,50,000.
Then why don't you file execution proceedings? Why are you waiting for him to go pay?
No, his evidence is struck down and he.
Then we will dismiss this petition.
Yes, ma'am.
This matter is posted for dismissal as there was no representation on behalf of the petitioner. Please come here.
He has come
On
to,
21/6/2024, as there is no representation, the matter was posted for dismissal and the matter continued to be in dismissal. And this court has directed the petitioner to comply with the office objections. If it is not complied, the same shall be dismissed without further reference to the court. Now, it is a case of the respondent that in spite of an order of the court,
for payment of 25,000 as interim maintenance.
he has not paid
He has
any
not paid.
amount and the arrears runs into 4,20,000. 4,20,000.
Yes, ma'am.
4,20,000. As there is no representation and the petitioner appears to be not, when an order is passed, unless and until, give that,
He-
when is,
he-
what is
he-
the
he
conditional order that
obtained-
is granted?
Obtained a stay on the condition of payment of 1,50,000. That's all he has paid below.
When an order is passed by this court, on which date? Date, when he has obtained an order from this court on condition of paying so and so, according to the learned counsel for the
Before
petitioner,
before our appearance, it was granted.
the same order is also not complied with. In, accordingly, writ petition is dismissed. Obliged. Yes. Who appears for the respondent? Learned counsel for the petition is present, heard in part, no representation. Yes, please make your submission.
Please, ma'am. Yes. For partition,
Suit for partition.
partition.
Hmm.
In which the fifth defendant is a purchaser.
Hmm.
Not from the plaintiff, but by the defendant.
No. Suit for partition. You are,
I'm one of the co-partners.
you are the defendant in the suit,
No, I am the plaintiff.
plaintiff in the suit.
The defendants are 1 to 5. 1 to 4 are my own, it is co-partners. who are
Co-partners of
entitled
the
for a
joint
share.
Hmm.
Fifth defendant is concerned, he is a purchaser.
From
The defendants 1 to 4,
1 to 4.
not directly. There was only an agreement to sell, which was put to for specific performance that was recurring, and he has purchased it. Now, our case is, I am not a party to such suit or for decree, or I am not an executant of any sale deed in their favor. Therefore, my right for my share cannot be taken away by that decree. I just take my lord's attention.
So what
to-
is the IA that is filed?
IA is filed by the fifth defendant purchaser to delete certain paragraphs in the plaint, delete him, and also delete one of the schedules.
How can he ask for, how can the plaint, the paragraphs be deleted?
That is how it is done, but
Let's see
unfortunately, the court has allowed
let's
it.
go to that.
Yes. I first take my lord's attention to the suit prayer, which my lord finds it on 16, page 16.
Yes.
Declare that the plaintiffs having 1/5 equal share by meets and bounds in the suit scheduled properties along with the defendants 1 to 4. That is what I said. They direct the defendants 1 to 4 to hand over 1/5 equal share in the suit scheduled properties as a legitimate share to the plaintiffs. If the
Yes.
defendant number 1 to 4 failed to do so, this honorable court may kindly appoint a court commissioner and demark a share of the plaintiffs under these sticks and means of the law and hand over 1/5 equal share in the suit scheduled properties. The third one is declare that the decree in OS number 40 of 2007, that is suit for specific performance, by the defendant number 5, again the defendants 1 to 4, in the court of Honorable First Additional Senior Civil Judge Bangalore, Davangere, dated 26/8/2010, is not binding upon the plaintiffs and the
Yes, I have
plaintiff.
seen that.
That is the case. Now, the fifth defendant files an application for deletion of his
Now,
claim.
we'll see his IA.
Yes, ma'am.
Where is that?
My lord finds it on page 33.
30.
Application filed by the fifth
Under which
defendant
provision?
under Order 6, Rule 16 of the CPC. Under Order 6, Rule 16 CPC, read with Section 151. For the reasons contained, mentioned in the enclosed affidavit, it is prayed that the Honorable Court be pleased to pass an order to struck off para 4 of the plaint, item number 1 in the plaint schedule, and the name of the fifth defendant in the cost record. These are the three prayers sought for.
Name should also be struck there.
He should be struck off from the suit.
Huh.
That is, he is the defendant, one of the defendants who has filed this
That
application.
name should be removed. He is not, his name should be struck.
His name should be struck there.
Yes, struck. And also paragraph 4 of the plaint.
Please come
And
to the
so also item
impugned order
number-
now.
My lord?
Please come to the impugned order now.
Yes.
Let's read from the beginning.
Please, please. My lord finds it on page 43.
Completely keep CPC here all the time. Yes.
Before taking my lord's attention to the impugned order, I take my lord's attention to the issues framed by the court on page 53.
53.
Issue number 3 says, whether the defendant number 5 prove that the court fee paid by the plaintiffs is not proper and correct. Whether the defendant number 5 prove that the present suit is barred by principles of constructive res judicata. So these two issues are casted against him.
So the defendant number 5 prove that the court fee paid with the plaintiff
Yes,
is
that is
not
his
proper and
contention.
correct.
This
Whether
is-
the defendant number 5 prove that when the issues are framed on 17/1/2018. When did he come up with this application?
This application is filed, my lord, on 9/8/2018,
9,
8/2018,
2018.
page 33.
Now please come to the order. Impugned.
Yes. My lord finds it on page 43.
Yes.
This IA filed by the defendants number 5 under order 6 rule 17 CPC to struck off para 4 of the plaint, item number 1 in the schedule, and the name of the defendant number 5. So these 3 must be struck off. His name first, 2, the pleadings in the plaint, paragraph 4, and also schedule item number 1. In the annexed affidavit, the defendant contended plaintiff filed a suit for partition and separate possession. After the receipt of summons, he has appeared and filed a written statement. D5. The above suit is filed not only against him, but also against defendants 1 to 4 claiming the share in the suit shell properties. The plaintiffs filed a suit in respect of item number 1, RS number 145 measuring 1 acre situated at Bhathi village and remaining agricultural lands. Defendant number 1 to 4 and others executed agreement of sale in respect of item number 1 of the suit shell property in 2006. Later on, they are not executed the sale deed. Thereby, this defendant filed OS number 40 of 2007 against the defendant number 1 to 4 and the others in first additional senior civil judge court, Davangere, for specific performance of the contract. The said suit was contested by
Plaintiff is
defendant-
not a party to the specific performance suit.
No, I'm not a party to this. The said suit was contested by defendants 1 to 4 and others. Later on, the suit came to be decreed. The defendants filed EP, execution petition 92 of 2011 against defendant number 1 to 4 and others and requested to execute the sale deed by receiving the balance amount. In spite of it, they are not ready to execute the sale deed. In the meantime, the present plaintiffs filed miscellaneous 4 of 2012 to set aside the judgment and decree passed by the court in OS number 40 of 2007.
What is this observation? The very plaintiffs have filed, plaintiffs or defendants have filed.
No, plaintiff,
I am looking at
the
9, para number 9.
present plaintiffs.
You have filed not this, in the EP proceedings, have you participated in the specific performance EP proceedings? Because please come to point number 9. I'm looking at page number 45, about 4 lines from the top.
Yes, ma'am.
Huh.
The learned counsel defendant number 5 vehemently argued and submitted that the present suit filed by the plaintiffs for partition and separate possession is not maintainable against the defendant number 5.
Next.
He further submits that the suit item number 1 is the subject matter of OS 40 of 2007 and EP 92 of 2011. that is specific performance
Next,
suit
next.
and execution.
Next part.
Those matters are decided by the court on merits. The very plaintiffs are filed miscellaneous petition against the judgment and decree passed by the trial court in OS number 40 of
This
2007.
I want, this is what the clarification I'm asking.
Yes,
Is it correct? No, is it by saying, instead of saying defendants, they said plaintiff, or you have filed a petition in the execution petitions?
that appears to be not immediately because miscellaneous case,
So please clarify that.
miscellaneous case number ಎಲ್ಲೂ ಹಾಕಿಲ್ಲ. ಬರೀ miscellaneous ಅಂತ ಹೇಳಿದ್ರು.
No, this
Only
please
in
clarify.
execution petition they say.
No. The suit for specific performance was decreed against the defendants, one to four in the
1 to 4.
suit. Then execution was filed, that was contested. Now from this line, what this court is understanding is, like you also contested along with the defendants, this particular execution proceedings, and it was dismissed. That fact, please look at the file and clarify, will pass over,
Execution petition, we are not parties, but we have filed the miscellaneous.
will pass over. Yes. next
Miscellaneous
matter.
petition they say, my lord.
Uh-huh.
Miscellaneous petition they say, but
No, no, under execution proceedings, when you say, when you file a petition that it is not executable for so and so reason, when an order is already passed by the court that, what is that order? That is what is relevant. If that is not there, it is a joint family property issues are framed, that will be decided. What, even on that also about the res judicata has to be, issue is framed already.
my submission to my lord is, the execution petition, as I submitted to my lord, I was not a party because I was not a decree holder, nor judgment data.
But you
But
can, as an object, you can,
as an
objector, you
objector-
can find that.
If an objector, as an objector, if he participate, whether he can take away the rights of the shares of these plaintiffs.
As an objector, if you file a petition and an order is passed against you, against that, a regular appeal lies against that.
No, one of the judgment data themselves have filed a regular appeal which is pending.
It's not you. That's a simple thing I want to know, whether it is you or the defendants.
The
Please look at
defendants,
it,
the defendants 1 to 4 have filed the regular appeal.
not you.
Not, I have not filed.
You have never participated in the execution proceedings.
No.
In the execution petition, I have not.
That's why I'm saying there is a mention in the order by the court. Just have a look at it and please come back. We'll take it up in the afternoon. We'll pass orders in the afternoon. 2:30.
Obliged.
Yes, please.
Please, my lord. If I may be permitted to make a submission while my learned brother friend is to speak first though. That's the last instance when this matter came up before my lords. There were two parts of the orders that were given by this court. A, there was a visitation on Saturday and on Sunday. And then they were supposed to go the subsequent Saturday to Nimhans for a family counseling. Lords, I wish to submit certain documents pertaining to the visitation. If,
Have you given to him?
Lords, this carries the video footages of what exactly transpired on the Saturday and on the Sunday, along with some photographs. Lords, if I may be permitted to explain exactly what transpired. Lords, the respondent, as per the directions of this court, goes to the concerned residence of the petitioner. A day prior, he sends out a WhatsApp message and an email, which is part and parcel of the documents that I have submitted, which speaks about the address that was to be disclosed as per the order of this court. He also has prepared an itinerary that has been sent to her. Page number 6 and 7, my lords. There's a WhatsApp messages, which also includes the address that has been submitted as per the directions of this court. Page number 8 is the same thing sent by email, specifically enlisting the details of what he wants to do with the children. Like he will take them to a cafe.
Page number 9.
My lords, I'll come to the,
That.
yeah,
Already
I'll-
explained that.
so on the day, on Saturday when he goes there, my lords, from, as per the, again, the orders of this court, one counsel from our end, one counsel from my learned brother counsel's end, both of them were present. The concerned petitioner was not there at home. The petitioner's parents were there at home. They told the children to just come out. They locked the door. The video footages categorically show the son beating the respondent. The attitude was absolutely unbecoming of how a child would behave to the father. And the son is also seen stating that we will not obey or adhere to any orders of any court. My lords, an 11-year-old child will definitely not say these words unless he is tutored. It just doesn't stop here. Subsequent to this, the petitioner's father calls police by dialing the distress helpline, 100 or 112, whatever. The police comes and the police is seen advising the respondent, no, you go back, the children will not come. It's an order of a high court, my lords. We have categorically shown that also to the police. Police had no business to interfere in the matter when the High Court is seized of the matter. There is a counsel on record of theirs who's seen interacting with the police, and the concerned counsel locks the gate and tells the children to go inside. The respondent with the other counsel from the office waits patiently for 3 hours, and he goes back. Next day morning, when it was at 10 o'clock onwards, visitation, and when he goes to visit there, he's intimated by the petitioner that the children are hospitalized because of the stress that the respondent caused. The video categorically shows how, with a lot of love, care, and affection, the father was interacting with the children. When he asked the duty doctor as to why the children have been lost, the duty doctor says, the children are fine. I have done this at the instructions of the managing director of the hospital. With all respect, he goes, speaks to the hospital authorities because he is paying the insurance for the children. He says this hospital is not of absolutely good quality where the children can actually be treated. I am paying the insurance. Let me take them to Astor, or let me take them to Columbia Asia or any other better hospital. My lords, the subsequent photographs in page number 10 is the condition of the hospital. The other photographs are of the previous day. Now, my lords, when he goes and meets the concerned managing director of the hospital, he questions, are you the guardian? Who are you to come before me? Let the mother say, discharge, I will discharge. He is stating, the custody is not yet been decided. I am the father. I want to take my children to a better hospital. At that juncture, again, the father of the petitioner, so mother of the petitioner who's present at that hospital, calls the police. The concerned Pina police tells the respondent to get out of the hospital and see him in the police station. He again reiterates, it's an order of a high court. I have come to exercise my visitation. I want to take the children to a better hospital because I don't see this hospital having all the absolute facilities. He is still denied. The matter was listed on 8th. They sought an adjournment. As early as 2 days before, the Pina police calls the respondent, harasses him. When he says, these were all done because of the High Court orders, they say, let the High Court pass an order on us, we will see, you should come and appear before us. This is the amount of influence that the petitioner has done in terms of utilizing the police instrumentality while there were orders subsisting of this court. At Nimhan's Milots on 7th, the respondent reaches the place at the given time, meets the concerned CMO. Nobody from the petitioner's side, neither the children nor the petitioner appear. They are there till almost 3:30. After that, they come back. And the concerned report is also tabled before my lords. They have absolutely been contemptuous. And this is where we stand, my lords, on my lord's order as far as how the visitation went.
Yes. Yes, Mr. Kant. Would you like to file your reply to that?
My lords, yes, I would like to reply
Please file a reply.
with reference to the video and audio coverage which we have made at reference at the residence, and also the condition of the child the next day. I will definitely file a reply with proper, what is that, CD and all that. It shows, voice could also be heard by my lords, so also the pictures. Yes. And secondly, what?
Either ways, either if it is the
Allah-
petitioner, mother or the respondent husband,
Yes,
whoever are in this process violated the orders of the court,
yes,
shown disrespect to the orders.
yes,
And behaving in a manner
yes,
which is not expected,
yes,
will face
Yes.
the
definitely.
heat of it.
That
Yes.
apart, my lords, let us, I will file reply. I will convince my lords as to how he behaved on that day. See, here is a forum where we are trying to establish the relationship between father and child, who has gone absconding from 2017 onwards. All of a sudden, see, children thinks that he is a stranger. He should learn to win the heart and mind of the children and take them along. If he comes that, yes, come with me, children definitely won't go. That is the reason why I asked my client not to be at home, because they may come and tell the court that you have influenced them and all that. I don't want to do that. But at the same time,
No, for influencing, one need not be physically there.
yes,
Yes.
therefore, let him establish that kind of love and affection. We welcome him. We don't want to deny his privilege of visiting the child. But they are not prepared to go because he has not established that kind of relationship with them.
Right from this petition is filed in 2021. We are
Yes,
in 2024.
he has not turned up, no contribution absolutely whatsoever, no connection whatsoever from 2016, 17. In 17, he files a petition for habeas corpus petition. Thereafter, he sleeps over the matter. In 19, he files GNWC, sleeps over the matter. Now, all of a sudden, if anybody comes and tell the child to
You
go,
just tell the court how it will happen.
pardon me, lords?
You please tell the court how it should happen.
It should happen this way, my lords, because in my experience in representing these kind of matters, what I would request is, let there be a supervised visitation, at least once in a week to him. And let us see how children get along with him. Let us see how he established. And in the meantime, there should be certain amount of sacrifice and in him in contributing to the welfare of the family. Thereby, see, nobody will part with money unless there is a selfishness or sacrifice behind.
No, but
Let-
on the last occasion, the wife said, I don't want.
Pardon, my lords?
The court was saying,
Yes,
the wife said, I don't want money. That I recorded in the earlier order.
yes, that, because, why? Because, my lords, kindly look to his conduct. He gives one posted check, one check. We don't know whether the balance is there in that account also, which we have to.
Not when something is.
Yes,
there before the court.
Therefore, no, from
No,
the
but
beginning,
That reply of the wife, that day it was given to the court, it was recorded.
But-
That's why it is kept in the seal cover here.
Yes,
the
yes.
DD.
yes,
So
what
now when
I would
once-
suggest,
No, on one occasion, I want a financial support.
what,
On other occasion, I do not want.
my
Both of
lords.
them can't go together.
from the beginning, when this matter came up for admission, they entered caveat, this was the suggestion made to them. Kindly contribute something to the family, kindly earn their heart, kindly don't disassociate yourself with the family. We will give you visitation, right?
No, please tell the court, how will he associate unless and until you permit him to do it?
Let him come and see the child. We are not in some common
What has
point.
happened yesterday?
Pardon me.
Is this yesterday, do you think that?
My lords, if I place records before my lords are definitely convinced
Then
about
we will
this.
see the record.
Yes, yes,
And
my
one
lords.
more thing in this particular case.
Yes.
Till now, court has never passed an order
Yes,
unless it has always been a consent order.
yes,
If by looking at the records.
yes,
I think this would be the first case where this court would be passing an order, shifting the custody from one parent to the other parent.
yes, yes.
Because of the interaction this court had
yes.
in the
yes.
chambers, what this court has observed and how the manner in which the mother is influencing them. The moment she starts crying and she starts telling something about what has all happened, I can see that that emotion in the children
Yes.
and how they started behaving
Yes,
and what was their reaction before her emotion started and before and after it, what was the reaction. So there are, because every time I've recorded everything in on the proceedings, everything is on record. Now, the court wants to be, it has to be a balanced one.
yes.
And
correct.
court has given enough opportunities, enough interactions are done. If this is the same manner in which, let her come out with the open and an appropriate manner in which not telling that the children are not interested. I'm just telling you what is going to be, so that if you advise your client and openly if she comes up with something which practically happens, or else after you taking your affidavit on record, the court will be compelled to pass an order which is of not to her liking.
Yes, I agree. Why it happened? Because kindly imagine the plight of children who have not seen him for years. For years.
17 to 21 is they have come here. No,
No, not before. From 2014, he abandoned the family and left. He has got the history of absconding himself. I have stated in my petition
No,
in detail.
then is it a reason that the children shouldn't talk to him? What will they have?
Let him talk. Let him talk to children.
Why they are not talking?
My submission is, let him establish the relationship with the children independently.
Yes.
We don't stand in his way. Let us see how it
Like
works.
it is like this. He
Yes.
has to establish independently.
Yes,
Children will not come out. Because children are not coming, we should give them time. It should be
yes,
taken slowly.
yes.
And it would happen after 16 years when they become major.
No, not like that. Not like
What
that.
slowly? Why should it be? How slow it is? From 21 to 24, the matter is pending here. Is it
My
not?
lords, after this honorable court suggested him to deposit money for the maintenance of the family, he just vanished. It is not that this interim order is also passed before their entry into the case. He did not make up his mind to move the matter at all.
So the one thing is, like, let me understand it clearly. Unless and until father takes care of the entire, the responsibility, monetary responsibility of the kid, the mother would not let the
No, not
bonding
like-
to develop.
No, not like that. I'm not on that.
There are two independent things.
No,
Now, if the father is not taking care of the
Yes,
children,
yes,
it is an issue where the court will have a different finding and understanding about the responsibility of the father.
correct.
That is a different aspect.
Yes, yes.
Now, when it is coming to the way, the manner in which the things are taken forward from the side of the mother with regard to the children, at least talking to the father, not that they have to, they are good, the court has passed any order that they should be very happy, they should do on that. Whatever the mother is saying when they are listening, please, court will not accept the fact that in spite of mother saying it, they are not listening. Court have if I understood it in so many interactions the court had. Now, this is a very, very clear case of parental alienation for whatsoever reasons. That's why please advise your client, come up with this thing. But
Yes.
100% in this case, this court is going to shift the custody to the father. Then only all this bonding, then only will happen. Otherwise will not
Let us
happen.
not take such decision.
But
Let
what to
us
do?
peruse the material
what
what
to
I am
do?
going to produce.
That's what I'm saying, subject to what you say,
Yes.
As of now, the court's impression is
Yes.
that she is not cooperating or she is not obeying the orders of the court. That is the impression of the court with the interaction that you cannot deny it
Yes.
because it's my impression and my understanding
Yes.
about what has transpired. So please come up with your objections.
Yes.
Court will look into it
Yes.
and also indicate to her what is the intention of the court.
Yes, yes,
Yes.
please.
Pose this matter next on when you can file your objection.
1 week.
My lord, next
Pose
Friday.
this
my lords.
matter on Friday, not possible.
Yes.
Pose this matter on 18th Thursday.
Please.
Yes, next.
My lords, if I may just make one submission, my lords, because he made certain amendments.
No, that anyhow, we are not considering it. He'll come up with you want to file anything to objection or whatever it is, let file. Let everything be record. Let us not waste another, some more time on this. Yes, please.
Grateful. ma'am.
Short
Yes.
question for this court is, my lord, whether video conferencing could be made as a. Oh, my lord. I had requested my brother counsel to take a Passover in case I don't teach.
Notice is served. When was
It
it?
is served, my
Take the name of,
It is served in the name of both the counsel appearing on
And
behalf
to
of
the-
him as well
yes.
as the parties concerned.
yes.
I filed a memo to that effect the day
Let's see the
before
Q
yesterday.
order.
Please, my lord. My lord, the issue in this case, my lord, is whether the DNA report, which was given on the basis of a consent between both the parties, could be marked as an evidence through video conferencing. My lords may kindly take page 44 of the petition, my lord.
40?
44 of the petition, my lord. In this case, my lord,
Yes.
43, if I may apologize. Both the counsels are present. Counsel for respondent filed memo stating
Go
he,
For the wife or husband.
for the father, my lord, for the
For the-
husband in this case,
Hmm.
stating he has no objection to allow the I number 5 and
Sir,
respondent
what is the MC?
on the grounds of adultery, my lord, divorce, please.
Filed by whom?
By the father, by the husband in this case, that is the petitioner.
Hmm.
There, my lord, the
No,
petitioner
he's, even the paternity of the boy is in question.
is in question and there is a DNA report to that effect confirming that he is
Let's
not.
read
the
it,
father.
let's read
Please,
it.
my lord. Here, my lord, IA number 5 and respondent is ready to subject herself to DNA test at the cost of the petitioner. Both the petitioner and the respondent undergo the DNA test. The DNA test report is in
The
fact,
respondent is ready to subject herself to DNA test.
please, my lord,
That's a wife.
please, my lord.
Hmm.
Pursuant to which the wife and the petitioner, that is the husband, subject themselves to DNA test at Hyderabad.
Hmm.
The DNA test report, in fact, is handed over by the concerned officials there to the wife in order to produce it to the court. It is brought before the courts. For the purpose of adducing it as an evidence, an application is filed. The application is allowed and it was due to be marked as evidence. In the course of which, my lord, the Honorable Family Court issued summons to the director of CFSL Hyderabad to come on record and adduce his evidence because he was the signatory to the report. He just makes one application, my lord. He writes a letter to the concerned court.
Where is that?
That letter, my lord, we do not have access to it, but it is on record, page number 72.
Hmm.
Petitioner and respondent and their counsels are present. Page 72, my lords. The lower portion,
Stage of arguments on me,
the lower portion, my lord.
family court, so and so, for recall of PW1.
Page number 72, my lord.
No, it's filed by the defendants, or the respondent by IA.
No, we had filed it. The husband had filed the application, my lord, to adduce it as evidence.
Hmm.
Page 72, my lords, the lower portion, if I may read it, my lord. Witness by name, Dr.
Start from 68.
68, please, my lord. 68 is, my lord, IA is filed at the stage of arguments on the main petition. IA number 7 is
Where is
filed,
the present order?
please, my lord.
Where is the present order?
This, my lord, page number 74 is the concerned,
74.
72, I apologize.
Read from there.
Lower portion, my lord. Petitioner and respondent and their counsels are present. Witness by name Dr. Dash, Director CFSL New Delhi, has sent a letter to this court requesting arrangement through virtual mode to record his evidence. This, my lord, is what we seek enforcement
Hmm.
through this writ petition.
Hmm.
Thereafter, my lord, it is contended by the wife that no, he has to come down in
I
person.
think you can read it further
Please, my
also.
lord. Both parties and their counsels are present. Shri M.K. advocate prays for taking steps as per the letter written by one of the witnesses by name dash New Delhi. Shri NKK respondent prays for physical recording of the evidence of this witness. Shri NKK for respondent prays for filing application in this regard. Next state, my lord, petitioner is absent, respondent absent, but respondent filed IA under section 24 of Hindu Marriage Act and objection to the DNA report, not to the application, to the DNA report. Petitioner filed memo, objection to and memo and for steps by 1312. Next, my lords may kindly come to page 76. Case is advanced. Petitioner is present. Respondent and her counsel absent. Counsel for petitioner filed memo with copies of advancement IA, postal receipt and courier receipts. Shri MK for petitioner submits the date of advancement intimated to the counsel for respondent by post and also by WhatsApp message. Respondent called out, absent. Petitioner filed objection to IA number 9 filed under section 24 of the Hindu Marriage Act for appearance of respondent and for steps and to hear on IA number 9 and on memo by 26/3/2024. Thereafter, my lord, it is proceeding on the same basis. Steps are continue to be taken in order to request.
Where is, it is a request made by him.
Please.
Where the court has rejected it?
The court has not rejected it, my lord. The
Then-
court has not at all rejected it. For the last 9 months, my lord, it is going on for the purpose
So
of taking
why
steps.
For this court?
Seeking, my lord, directions that the evidence could be taken through video conferencing.
No, unless and until there is an order, why should there be a direction?
My lord, because this honorable court, while framing guidelines for
That is a
video
different
conferencing.
aspect.
Please.
That the case would arise when the court rejects saying that it cannot be done, you should do it physically. Where is that occasion and where is that situation has come now?
Ma'am, for the last 6 months, my lord, the PO was
Then you
absent.
have another option.
Please,
In
please,
that case,
please,
directing the court to do it.
Please.
But how can you re-seek a positive order from this court?
In the
Without giving
alternative-
An impugned order.
In the alternative, my lord, what I would seek is an early completion of the trial, which is my fundamental right. Because within 3 months, for the last 9 years, my lord, this divorce proceedings are pending.
You can
Now-
come to the court with some specific relief.
That
No,
is
had it been that this is of a MC of 2019.
2017, my lord.
Now, if it is 2017, on the first occasion itself, this could have been disposed of.
Please, my lord, that was my prayer. On the first date of
No,
hearing,
we were asking for this relief.
my lord, I had requested that the early disposal could be the main relief. I had, in fact, on the first date of hearing, my lord, I had made this submission.
The petitioner,
My lord, only one aspect I want to bring to this honorable court's notice is the conduct of the respondent. Despite, my lord, having protective.
19, not 17.
2017, my lord, it was filed before this honorable court in Bangalore. Thereafter, this honorable court directed for the proceedings to be transferred to Davangere, which is where the current proceedings are pending. From there on, my lord, even as on today, the stages of evidence.
What is filing before this court?
She had filed a civil petition seeking transfer of the proceedings to her jurisdiction.
MC is filed in Bangalore.
Please, it was at the first instance filed in Bangalore. Thereafter, it was transferred to Bangalore.
The present petition is filed, seeking a mandamus to dispose of the trial as expeditiously as possible. As originally this MC is filed in the year 2017. And thereafter, it is renumbered as MC number 306 of 2019. Then counsel for the petitioner submits that on one pretext or the other, the respondent is protracting the proceedings. And considering that this is a MC of 2017, the same has to be, that there shall be a direction to the court below to dispose of the MC as expeditiously as possible. Without going into any of the allegations with regard to the wife protracting the proceedings and all, considering the fact that this is an old case pending, and as this court is passing orders for all the MCs which are of till 2019 for expeditious disposal, this court deems it appropriate to dispose of this petition, directing the trial court to dispose of the MC as expeditiously as possible, but not later than 6 months. Next, before this, notice is served on the respondents, and there is no appearance on behalf of both the parties. Yes,
Great.
next.
For the petitioner in this case, your name is.
Because in this, your lordship had directed me to file an affidavit. I have, I have served the copy.
Take that. You have a copy?
I have a copy. I have the,
Objections to that?
yes, I have the objections ready. I'll give it. At the outset, I would say this is the third affidavit in which they have lied. Third, she was not even present on the day when this event happened. And she is saying that I heard him defame. If paragraph number 3 of this affidavit may be looked at, she says that I have made a defamatory statement against her in an open gathering of 200 people. First of all, it was a place where a decision had to be taken, whether a particular proposal has to be passed or not. It is like a legislation of the Bangalore club, to which she was not a party. So as such, she saying this on affidavit that I defamed her is a hearsay evidence and cannot be permitted. I am giving my objection as well.
It's not about the technicalities. No, we are not done.
No, I have not defamed her at all.
Now, whether you have said it or not.
I have not said. It is a, see, there, what has happened, there is a proceeding asking whether if there is a matrimonial discord, and in fact, I was not even the proposer of it. I didn't even give the propose that there should be some rule like this. The only thing is whether pursuant to some discord, if a spouse who has been made a dependent member, can that person, permanent member, does he have the option of removing her? Reason being,
He removed her.
he said, because this provision was not there. A proposal came that there should be power to the permanent member to remove her, to remove the. Then that resolution was passed. Then pursuant to that, I made my representation, saying that because the reason being, whenever anything happens in the club, she will not be responsible. I have to take the responsibility. And another thing which came into the discussion, which the person who had the issue over there, who proposed this change, he said that in his case, husband was in the club and there was his wife sitting with her paramour and he was made to pay the bill of the alcohol. So he's like, I cannot let this happen. In that case, it was proposed by that person. And they asked who and all support this and who do not support. Out of 200 and around 150 people, 150, 175 people have supported it. It was by raising the hand. Vote was by it. So this is what is the story. And this is as per his, see, if he's a member, he has a right whether to have a dependent member or not. But now the situation being that there are adversaries. If anything, if she does anything, if she abuses somebody, if she drinks there and gets squashed over there, who's responsible? Whose membership will be at stake? In fact, she is saying that she is using the club for children's welfare. That is not the case. I have produced documents to show that on the very next week, when I was admitted in the hospital, she was consuming alcohol in the same club. The reason why people use club, Bangalore club especially, because the alcohol is cheap. It has nothing to do with children's play area. I am giving my objections. And she is saying that a lie on the third occasion. She has stated on affidavit that her brother is not staying in the same house. In fact, I have a photograph wherein the brother is holding both the children. And that is my threat. The entire petition is filed because I am threatened of the person in the house for the safety. In fact, court says that, family court says in respect to his petition that he should be kept away from his own daughter. And my children have been given him as a fodder. This is my submission. I am placing this on record.
Copy.
Of the memo, if page number, the last page may be looked at. Page number 11. This is after they gave an affidavit. Brother is holding the minor daughter and the son is there. In fact, I am not interested in producing any more photos. Thing is, I am left remediless. And he is not accused of some minor allegations. May I read the allegations what are against him? In the charge sheet, not my allegations, not the allegations of the wife. It is the allegations in the charge sheet, which was pursuant to the second order of the Honorable High Court. In the charge sheet, I had filed an amendment application. I have produced along with those documents. The charge sheet, in fact, they are so disgusting that I cannot read them in the open court. The allegation, the findings by the inspector. In fact, his search history has been provided
Against whom?
against Abhinav Lal, the person who's holding my children.
That's,
If for a moment these documents may be looked at, my amendment application at page number, in fact, he is very much residing in the same house. I can produce video also, but I'm saying that I'll restrain from producing further videos. The issue is about the safety of the children. Custody can be decided later, but what about the safety of the children? The amendment,
Look, this issue,
my.
this issue was already argued and it was put to rest by me filing an affidavit. In fact, for more than a year now, he's been staying apart.
He is holding the children.
He-
I can
the
produce
not just
documents.
the affidavit, even the rental
Base-
agreement.
Basis of a affidavit. If it is to be, she is
If you
lying for the
want
third
to
time on affidavit. I have filed a perjury application her as well in the lower
What
court.
photo they produced
This is not
and they-
old photo. This is, you can, the age of the child can be seen. For a moment, if amendment application documents may be looked at, it is so perverse. It is very disgusting also, your ladyship. It shocks the conscience at how such a person, even the statement of the minor daughter is there. Every time I come up with a POXO issue, there is an issue with respect to Bangalore Club. Then there is an issue which comes up about the child's education. In fact, I am saying everything will happen as and when time comes. See, they want to send
But it's
a
only today
2 year,
that he has
two-
come up with this.
2-year-old,
All the while, they
2-year-old.
never brought this up because this issue was put to rest.
This
I
is
have
the main,
filed-
this is the main prayer of the writ petition.
I request the advocates not to shout in the court because I can hear, I have a
Yes.
hearing problem. There is a small atmosphere in the court be still congenial. Yes, I have all the patience to hear. How much time you argue, I'll hear. So yeah, whenever the other advocate is arguing, let both of you not exchange and give the, some peace of
Indeed,
mind to
indeed.
the court to
Indeed,
pass
indeed,
orders.
indeed.
Yes, yes.
Because in fact, an affidavit is filed and I also said that I also submitted that his rental deed, whatever proof that needs to be filed, that he's staying apart. I'm ready to file.
No,
However,
time
the
has
court
come.
had-
No, I'm telling you, the time has come. No, the court has not, no, it is, writ petition is filed in the, from several occasions, so many orders are passed.
Correct.
Now we will put everything to rest.
Yes, indeed.
Whatever the disputes that are there, you settle it in a manner known to law. Now, as far as the custody of the children is concerned, I mean, the visitation rights of the children are concerned, that weekend to the with the grandparents shall continue until further orders.
Milas, le-
Your
Milas,
Lord,
let
ladies-
it be,
Let it be on a Saturday.
let it be on a Saturday.
It'll be on a Saturday, the
Yes.
whole day, the whole day.
Milas, Not the whole day, Milas, because the second child, no, the first son is still not the whole day, considering that they also,
Second child, whenever the child.
because she's
comes
too
and
small.
Uncomfortable. she'll
I
be
will
sent-
drop her back.
Wait, Mr. Counsel.
Yes, yes.
She will be sent back. As far as the first one is concerned, on a Saturday till further orders, until further orders.
In the GNWC
In the
blocks.
GNWC, it will continue.
Milas,
And other
son,
disputes-
yes, son, he's
other
capable of expressing himself. Your lordship also knows that. The
Girl will
daughter,
also-
Mela-
no, girl will also go.
But let there be
Whenever-
time fixed so that she
whenever-
can pick up the child because her sleeping habits are different and
No, it should be like this. Whenever she says she's uncomfortable or she wants to go back.
I
she will
would
be
just
sent.
urge your lordship to
It will
just fix a time for the daughter being, because she doesn't eat there and then she comes home hungry and then she doesn't,
Then let
it becomes
let it
difficult.
go For the boy from 9 o'clock to 5 o'clock.
Plus 10 to 5 millards,
10 to
10,
5 o'clock.
because
and
he
this
gets up
girl-
late.
Girl will stay from 10 to 12.
10 to 1,
Can be
10
permitted to submit.
12, 21 is
Once she
fine.
makes a submission, I want to make my submission.
Yes. Tell. Yes,
This,
you can
this, if I may request your ladyship to look at IA number 5. IA number 5 is not for interim custody during weekends. The reason why IA number 5 was filed because there is apprehension. Even the POXO Act says that whenever there is apprehension of committal of there being any offense in future, then I can proceed as per law. I went to the police station. This court says you don't go to the police station. If I may read the POXO Act.
Against the mother, POXO.
What is it you want to read?
Till the time this petition, GNW is disposed of, custody may be given to me, keeping in mind that person is still,
Will not be granted.
Your
That will-
ladyship,
That will not be.
Your
considered.
ladyship, may I take you through the documents? May I, because the very GNWC case which was filed by the mother, what she had, the honorable court has said that he should not have access to.
Again reiterating something which is already lost, and I think whenever the advocate change, for I think the third time or fourth time.
That's fourth time.
Whenever the new
Your
advocate,
ladyship,
no, please understand, whenever the new advocate comes, again, the story will not start from the beginning. What has transpired, they should tell you, and now this is not the stage where this court going to go into all those issues. Now, the only issue is whatever that interim arrangement is going on, it will continue. Custody, changing the custody, looking at their age will not arise. These are
Your
all
ladyship,
issues.
there is a sexual predator in the same house. There is.
So if you found him in the club bar, does it mean that he's staying in the house?
He is not in the club. He is in the nearby shop. I can show where he's entering an egg.
No, then the court will, on the last occasion, he has filed an affidavit before the court for filing those kind of things. Then I will also start, on the last occasion, in fact, I wanted to take it on record, but still the court has not taken, that I will take it on record.
He has not stated anything defamatory.
Everywhere, the wife was
Your
going.
ladyship, my only
This
submission.
is, your client is taking it too far. Your client is taking it too far. His intentions appears to be not normal right from the beginning. But only considering the fact, and after the court has met the grandparents and the association and the attachment what they appears to have with the boy, the court is passed, order is passed. Had it been with your client, with this kind of the balance he's having, I don't think any order need to be passed. The GNWC can wait till
Your-
orders are passed.
Your ladyship, the issue is regarding the safety of the children.
In fact, my
In
lords,
fact, I have produced,
It appears that children can't be safe with the father with his mindset.
your ladyship, the only recourse that I have,
Last time with so many,
yes.
the chat and other things, so many were.
Yeah, all those chats, I didn't even have the phone on those dates. I was, in fact, they are saying that I have messaged them. I was in hospital on those dates.
from
We
2016.
will record that, if you want a case, whatever you want to do. Now, we will consider their statement,
But it's
saying
also-
that a person staying in their house, or if once he has come to visit, so what is wrong in it?
Your ladyship, in fact, he is staying there and he has given address on affidavit to the court in other cases.
That was earlier.
It is his
we talked
residence,
about
it
earlier.
is his residence.
At
In
least, are
fact-
you aware that this aspect was earlier addressed by the
Considered, yes, my
councils
lords,
appearing,
yes.
and they
It was
also
put to
said
rest.
we are not going into that issue. At least they must have at least given you those.
No, your ladyship, because IA for amendment is still pending.
That we will discuss it now.
Yes, yes, because
This is not.
in
the-
fact,
the markets
if
were-
I may request,
Yes,
if I may
You
request, then
just want to say by hook or crook, you want to take the children away.
Yeah.
What is this kind of approach?
Yeah.
She is not at all interested for the welfare of the children, is it so?
your ladyship, the conduct
Let's
in the
also-
present case.
No, you want to fight the attitude of yours, deleting the wife, and the number, this thing from Bangalore club, all this shows that your vengeance and your attitude.
All the clubs, my lords. All the clubs.
That is not right. If you're, as long as this MC is pending, this GNWC is pending, you will, the boy will come on a week, you'll have on all any birthdays, on any, okay, every Saturday he'll be coming, and the girl will come between 10 and 12. And if she wants to stay back, if she will stay back.
Yes.
And she is not interested, if she's too small, if she wants to go back, let her go
Yeah,
back.
may I
Let the
request,
GNWC be heard and decided.
may I request that it may be overnight
It may be.
for the elder one. Elder one is much comfortable, your ladyship.
No, my lords, that I have objections to that. Let it be, let
Sir,
it continue,
what
my
is
lords.
the
Let them file an application.
Objection that the mother has.
Well, let them file an application in the GNWC because I brought it to your lordship's notice that what is the level of tutoring that the father does to the child?
You
Your
have
lordship-
6 days with you.
Well, let's,
You do.
in fact,
you
it's
do-
only,
No,
let's,
no,
let me just.
Tell your client to do the remaining work. That's
Milords,
what is happening
Milords,
now.
let me just submit. In fact, Milords, your lordship wanted to just send the child only because of the grandparents, if your lordships recall, and not just the father. But then
Correct.
father,
That was the reason.
yes,
Even grandfather is there.
because father
Grandfather
is
is there.
extremely abusive and he has.
There is nothing to substantiate
The
that he is a.
Milords, in front of the children, he abuses to the child also. He reprimands the child. If you don't do this, I will do this.
No.
I will punish you. I
No,
will
no.
not give this.
No. Whenever
child
these
is
kind of things,
petrified.
no, whenever these kind of things happen and the child informs the mother, let her inform it
Not,
to the,
not,
to the,
Milords,
no, let her inform it to the GN, to the court, trial
because
court.
that one thing I just urge your
that's
lordship
the-
not to consider because let them file an application, let it be heard and it will be coming before your lordship.
No,
Or
no.
Milords, let the boy be
Why
called
not
and then
the- why
taken
not-
it.
Why not the boy has,
Plus, let the boy be called and if he is comfortable, if your lordship
He
feels.
is
Very
then
much
fine.
comfortable.
he's comfortable.
No,
Let-
Milords, on that aspect, we have not gone at all. In fact, your lordship could not
Boy-
ask the
no,
child at all.
The fact remains is that before their separation, they were going months and months. That's what's been stated in the photographs.
It was
are also
not
saying-
months and months. That is false. That is only few days. Yeah,
Days?
every time, yes,
When you
4
can-
days or
you can
5
leave a
days.
Small boy.
No, correct.
No, when you can leave a small boy and leave for weeks, now he is old enough to stay.
Also the parents also they have few houses, farmhouse and other things. They keep traveling. The father cannot take care of the child at all.
Whenever the grandparents are
I
there,
urge your
whenever
lordship
the
to-
grandparents are there, then they will have. That
Plus,
I will
I urge your lordship to just, I will keep the child present. Let it be after considering, no, speaking to the child because
He
let
was
the
in a-
child be.
He was in a state where he doesn't even want to go with the mother. He was
No,
saying,
Milords.
he was
No,
saying the
that is not the
grandmother,
thing.
he was saying that the
No, if
grandfather
that is
to
the
hold
case,
him and take him.
No, that is why I said, let the child be called, Milords, whatever your, if
You
you,
interacted with him.
no, that it could not be done because if your lordships recollect, he was called, but the interaction could not happen with the child because he was with the grandparents and mother was only
fact, he ran away.
interacted. And father never came before the court. If your lordships recollect, Milord, father has never come before the court, any of the courts.
boy?
Milords,
What's the name of the boy?
Kavin.
Huh?
Kevin, K-A-V-I-S.
Kavin,
I met
Kavin.
him.
No, Milords,
No, I
he was
met
with the grandparents. He could not, your lordships could not interact with him because he ran that day.
No, I saw. That's what, in between he came. I remember him.
No, that's
And
what
the
I
girl
said.
was
He
very
could
small.
not be
I
interacted.
remember, and even-
Grandparents, yes, your lordship interacted
No,
with the
he was in a-
grandparents.
No, when, what has happened when mother came, he ran to the grandparents. When grandparents came inside, he came along with the grandparents. And he was sitting there, he was telling the grandfather that
Yes,
you only take me to house. I don't want to, I'll come along with you.
Yes,
What you were
yes,
saying.
house, yes, my lords, but that's what I said. Regarding the overnight, I urge your lordships to just consider this. I will keep him present at whatever date or whatever, even today also. Let it be just asked and then pass the order. That is all this thing.
Not
Because
this
let them,
one, not
because,
this one.
my lords, that one, this thing, I just urge your lordships to consider that, my
We'll
lords.
pass orders in the afternoon. No, nothing to ask.
Plus, let it be in the evening also. I will keep him present, maybe for 5-10 minutes if your lordship feels that
No,
he's
I interacted with
comfortable
him.
because-
He is too comfortable with the grandparents
Plus,
and
yes,
looking at the
yes,
history.
only for few hours. After that, even he wants to go back to the
That if he
mother.
wants to go, then they will be sent.
No.
Then he
When
will
it
be
comes
sent.
to, no, my lords, when it comes to order of, if an order is passed, that overnight he can. Hook or crook, even if the boy is crying, they're not the kind who will send. That is why I said
Well-
your lordship can just ask the child and then pass the orders. Because at that time, then
Child will tell. How will he tell?
also overnight, if the child is having any issues or he wants to go to the mother, it becomes an issue. That is it. Because he's also small. He's not very old enough. I think he's 4.5 or 5 years old, my lord. That's all. And for about,
Serial
No
number.
mentions, no.
No, I'm just withdrawing that petition, so I may be.
You take that, which now
Serial number 50.
serial number 50 dismissed, it's submitted that it is, why you want to withdraw?
The property is already sold, madam, so I'm not.
It is, the petition, the memo is filed, seeking to withdraw the petition.
There's an office objection which I've explained to the
considering
court
the-
officer that.
Considering the memo is taken on file and then view of the said reasons, the petition is dismissed.
Serial number 32, other side advocate also present.
Hmm?
Serial number 32, other side advocate also present. Any date, some inconvenience is there.
What is that?
Some inconvenience is there in afternoon, my lord. Any date, my lord. Serial number 32, my lord.
Or something, I think, cause list is not at all seen by the advocates. I think there is, I made it very specific to write on the cause list that I do not want to entertain any mentions at 1:30. Court is hearing everyone at 10:30. So why should you make a mention? And it is so embarrassing for the court to reject the request every day, in spite of the time entertaining. Please understand.
Sorry.
Dismissed as withdrawn.
ಇಲ್ಲ 2:30 I think it will continue. 2:30 ಅಲ್ಲ madam? 2:30 it will continue.
Mission. Serial number 34, my lord. Today, the matter may not be reached, my lord. This is only in respect of correction of judgment. It's a typographical error, man. Earlier, lower court judgment dated has been wrongly mentioned, that's all the thing.
30?
So 34, man. Serial number 34. Instead of 2020, it has been mentioned 2010.
Take that file. Let's see once it is taken. Yes. Take that file off. It is there.
Last order portion.
Where is that?
Last order portion. Instead of mentioning 2020, it has been mentioned 2010, that's all, man. Last.
Where is the order?
Judgment call of this.
When is the case disposed of?
Disposed on 21st March 2024. Serial number 34.
Where is the order?
Judgment.
Which piece number?
Last portion of the order portion, my lord.
Hmm.
Lower appellate court,
Hmm.
RA judgment dated 13/8/2010 has been mentioned.
Page number
26, my lord.
of the judgment. Yes.
Last order portion.
Accordingly, the order passed in.
Yes.
RA number?
RA number 44/2016 dated 13/8/2010, but it is 2020, my lord, that's all.
2020. Come, this is an application file under section 152 of the Code of Civil Procedure to correct a typographical error in the judgment dated 21/3/2024, wherein it is stated that at page number 26 of the judgment, wherein RA number 44/2006 is mentioned as this, or the judgment dated 13/8/2010, but in fact it is, in fact it is 2010 and 2020, instead of that it is mentioned as 2010. Hence, the said typographical mistake may be corrected accordingly. IA number, application filed under so and so is allowed, and in the operative portion of the order, the date 13/8/2010 will be corrected as 13/8/2020, in the corrected copy shall be issued. Yes.
But one mention on behalf of the members of the bar, there's one situation, Lord. What has happened is certain matters your lordships has posted for dismissal. Members had just asked me, so I thought I'll make a mention before your lordships. But these matters which are posted for dismissal, Lord, their concern is that let it not be dismissed after 4:45.
No,
Because
nowhere it is mentioned after 4:45. Let one incident be shown to the court where the matter is dismissed after 4:45.
Yes, lot of
I will
lawyers
make it
came and
clear- No,
told
no, I
me.
will make it clear.
Ah.
If it is after 4:45, I'll not even ask them to call dismissal matters.
Ah,
Ever
yes.
it is done.
That
Let
is-
them say with some basis, because court is very particular about it. Because 4:45, you do not expect the advocate to be at, in the court. Whoever
Correct.
is interested, they will stay back.
But what has happened in Bangalore, our practice, generally we have to rush to our offices. Some offices are located in the outskirts. And there we have to sit, see clients, then go back home. It's a huge thing, lot of traffic. in
No,
Bangalore.
but one thing is, no, if somebody tells you something, there should be some basis when it is mentioned before the court. If you are not coming to the court for several times,
Yes.
matter will be posted for dismissal.
Yes.
And in dismissal matter, that itself is a ground you're not there. I am not entertaining mentions, number one. Number two, after 4:45, let them, because my court is online. After 4:45, if one matter is dismissed for default, please bring it to
Because
the.
that is
notice
what
of-
everybody told me, so I came running.
No, let them tell
Lot of
whoever it
calls
is.
came and I was in
At
the
four
association.
forty-five, if any matter is posted, it's dismissed for default,
Very-
then please let me know. Because the court is very
And one-
conscious of
One
it.
issue, because this is a heavy roster with before your lordships. Many of them want matters to reach before your lordships. Because your lordships gives a conscious consideration and passes whatever is the order. But they want the matters to reach. That concern.
No, if
Their
the
concern
matters
is-
are coming for dismissal, that means,
That is okay, Lord.
no,
Not
that
affected.
means people are not coming. It's a red carpet welcome for the advocate to come and argue.
Yes.
No, I do not dismiss it on the same day. If you're not coming today,
Yes,
I'll post it tomorrow.
yes.
Then it will be, then I will look into it, then I'll
Yes.
record that.
So
and,
what they were concerned was, so sometimes 50, 60 matters are listed. The court takes conscious consideration of all the matters, but only about 10 matters, 15 matters reach. They wanted more matters to reach.
But
before-
how can I? Because the court is not doing any time pass on the bench.
I know.
I'm very focused on work.
Yes.
What
yes,
I
yes.
can do, I
See,
can
if your
do
lordships
to the
could-
best of my
Yes.
ability.
And there is really, we just request on behalf of the bar that at least if the list moves a little faster.
How?
Just, your lordships will have ways not to
No.
have it done faster.
Because if I do it that way, that next thing is, without hearing the advocates, court is passing the order.
Yes.
Now, whatever requires consideration. Now, what is pending from 2016, 2017, I can't do the miracle. It has to be taken it. And I believe in giving, to the extent
Full hearing,
possible,
that lot we have seen.
patient hearing. And unless and until you're being an advocate, I know how, what any advocate, no, what will happen when I hear your matter, you're happy that I'm hearing.
Yes.
If your happiness is somebody's unhappiness, that also
No,
court can't
in
help
every
it.
case, there has one is bound to be unhappy, one is bound.
No, not
Because your
that.
lordships
No,
can't-
not about the same parties in the same case. It is like, I'm hearing you.
Yes.
You're happy that your matter is heard. People who are sitting and waiting, why this matter is heard so much?
Yes.
So if it is like brushed it aside and something is done and next matter is mind taken, so it is like your happiness is somebody's unhappiness.
One another. But all this is the feelings of the bar. We want to share openly before your lordships. We don't have any qualms about it. While imposing costs, there are several youngsters are there. There is difficulty.
Cost for what?
Costs on the case. Suppose your
No,
lordships-
please understand.
What happens?
No,
I'll
no, no.
just- I'll
That
just
is,
put my
that request
perspective.
though I cannot consider because
No.
it's a judicial order.
Yeah, my perspective.
No. Costs for non-compliance, costs for something. It is not on the advocates. It is about a litigant who is taking undue advantage of process of law. That how can advocates request for that?
That is what happens. But I just put my perspective, leave it to your lordships, as a lawyer's perspective. This client will go to another lawyer. He will say, your lawyer, he is responsible for this, and he will start blaming the lawyer when he goes to another lawyer. And that lawyer will incur the wrath. No, moreover, in local bar associations, suppose it is Mysore, Tumkur, in local bar associations, that becomes a big issue. That lawyer may lose livelihood. That is why they simply
I don't
lag
think
about it.
that is not any of the cases I impose costs. It's not a question of livelihood. It is about cases where 40, 50, 60 crores of money. And no, in those matters only I'm imposing costs. Today, some case I've seen,
Yes.
1998 was the final decree proceedings. They were permitted to, the court asked them to question the final decree proceedings. Till today, 2024, without questioning the final decree proceedings, matters are going on. If it reflects on the advocates, court is not concerned with, when looking at a brief, it is, I can only hear you. That is a concern court can show to the advocates.
That-
But the
that's-
result and
No, that-
imposing costs,
we
that
leave it
can't
to-
be,
we leave it to your lordships.
yes.
I'm just putting the sensitivities of the bar before your lordships.
But
And for-
unfortunately, I have to
one-
say
one
that I
thing is-
can't consider
One
that.
thing is when your lordships came from AP, everybody was very happy and is still happy that you are really relief oriented. There's a lot of relief before your lordships. That is one good thing. And we will, that one issue now, that can be.
That I'm telling you, like, I don't tell you that I consider, when I don't consider.
Yes.
Because I feel that abusing a process of court,
That's-
nobody can be permitted. Here, you are not a part of it. Your client is a part of it. Who is abusing it? Why should the court just like that, the advocates do not, because it is not your mistake. or advocate do not matter here. And at the same time, no, I can't, no, I know Mr. Subbareddy, so I can't grant order to Mr. Subbareddy. I'm not granting.
No, Lord, it should not.
That in the same way, the cost also not to Mr. Subbareddy, it is to the person who is not right. And as far as this dismissal matters, like that is a wrong information you got, no matter, I'll tell the court officer, 4:45, look at the, don't call dismissal, let it come tomorrow. Other matters, whenever somebody is coming and saying, I said, I'll post it, because at least I know the
That's all, Lord.
difficulties of the
Yes.
advocates.
Because they'll have to leave at 4:45 and.
No, nothing, don't let them be rest assured on that, call the matter.
Correct.
Continue.
Make a request. Serial number 5, my lord was passed to Janet,
Passed over.
passed over.
Huh.
But the questions, to answer my lord's question, I don't have papers.
Huh?
I don't have those papers, copies of those papers.
Huh.
Kindly have it on Tuesday or Wednesday.
You want to submit after instructions. Land counsel for the petitioner submits that. They'll get specific instructions in this regard. He needs to get instructions. When do you want?
Wednesday,
Wednesday, post on Wednesday.
oh, sorry, Wednesday is a holiday. I'm sorry.
Wednesday is holiday. Thursday?
Yes.
Thursday.
Great.
So the petitioner in this.
Yes.
Page number 9. Messages which I had read earlier, but however I have 2 or 3, that is all. One is, I do not want a child. Digest that first. I will hate you for the rest of my life in whatever it is. So what? And he never wanted a child in the ensuing messages also. Not here, always here, his parents, in fact, he has told her to abort the child itself. All that the family cares about is the child. I'm sick and fed up. But even in the next thing, if the kid will be given a choice between me or your people, he doesn't choose me.
I think as I informed him, that stage is not there now.
No, correct.
That's over, that's over. All will be decided.
This thing I urge your lordship is, he's staying in the same house. He never came before your lordships to even interact with your lordships, or for that matter, when the parties were called. But he was never before any court for mediation. He never gave his consent. All that I'm asking is in view of this thing, that we have shut off all the facilities in the club. In effect, the children are also affected because they can't go to the club if the mother is not going. And then he has not paid the maintenance only because this court directed. He paid in May because he wanted for the vacation if the lordships recollect. From June, he has not paid maintenance at all. And the club facilities are cut off. And then abusive messages. In fact, your lordships will recollect that the father itself will not be entitled, whatever the court has granted, it's only because of the grandparents. The fact of the matter is, he stays in the same house. Father stays in the same house. I just urge your lordship and the parties along with the child, even if it is 10 minutes, whatever your lordships decide, I'm okay by it. I'll go down to your lordships. But let that parties, both the parties, father, mother, and the child, just.
How many times the court will interact? Please understand, court has other work also to do. Why should the court interact with the father?
Just because the court is inclined to give the, it's all my urging. This is all. Not more than 10 minutes, I just urge your lordships. to
This court,
interact with the parents.
Your Ladyship.
the father,
Your
the
Ladyship.
present petition is filed. Yes.
I have one judgment which I would like to place on record, which is on similar conditions, wherein in the house there was a person who's accused of POXO. Only that thing I want to bring on, nothing else.
The present petition is filed.
I will pick the children, your ladies.
The present petition is filed, seeking a modification of the order dated 5/1/2024, passed by the by the fifth additional principal family court judge, Family Court Bangalore, in JNWC number 137 of 2023 on IA number 5, and to direct the temporary custody of the minor child aged 4, Kevin aged 4 to 10 months, and Anya aged 1 year, 10 months be handed over to the petitioner. The court below, by order dated 5th January 2024, had granted visitation rights to meet the children in visitation room BMC on every Thursday between 3 p.m. to 5 p.m. And the father is directed to take care of the needs of the children, and also directed not to give objectionable food, snacks, beverages to the children during his visitation right. Further, father is directed not to give any ill advice against the respondent. And also, the mother is directed not to take the children from out of the jurisdiction of the court till disposal of the petition. It is the case of the father that the parties were married on 29/5/2014. And thereafter the same was registered at the office of sub-registrar. Out of the wedlock, they're blessed with 2 children. In view of the disputes arose between the parties, the wife, along with the 2 children, has went to the parents' place. And it is a case of the husband that the brother of the respondent wife is accused and charge sheeted of the offences under child offences under the POCSO Act. The petitioner is diagnosed with a cancerous tumor. For that, he had to undergo the surgeries. At that point of time, wife had left both the life left along with the children. Thereafter, he had given a police complaint that the minor children were illegally taken, and also filed a petition seeking custody in JNWC number 137 of 2023. And also filed IFI for temporary custody, and IA number 7 for visitation rights, and IA number 8 to direct that the children should not be taken outside the jurisdiction of the court. Earlier, petitioner has also filed habeas petition, that is WPHC number 57 of 2023, for handing over the minor children. But the same was dismissed by relegating the parties to the family court. It is stated that a second charge sheet was filed against the brother as he has not appeared before the court. It is the complaint that the wife is staying in the same house where he is residing. And it is his grievance that the interim custody is not given to him. The wife had filed her objections, taking several grounds. And it is a case that the brother is not staying with her and is staying in a different house. This court has heard these matters on several occasions. And interacted with the grandparents, mother and the children. On 4/3/2024, after discussing the contentions of both the parties, I directed the parties to appear before the court. Then on, in the order dated 13/3/2024, it is observed that in spite, while this case is pending, a complaint was given on 28/2/2024 to the Deputy Commissioner of Police, wherein he has mentioned that on 18/1/2024, when he went to visit his minor children at the visitation room, his children felt happy to see him. And about 5:15 PM, when the visitation time was coming to an end, the elder child started crying and called out for help. He refused to go back to the mother, but he was forcibly snatched and taken away by the mother and her family members. And according to him, such behavior is quite unusual and needs immediate attention in the form of protection. Pursuant to that complaint, on 12/3/2024 and on 13/3/2024, that wife was called to the police station. Then this court has, in the said order, observed that anything that transpires during the visitation rights is a duty of the husband to bring to the notice of the court. He cannot keep on filing complaints and also seek the visitation rights. Though this court is not happy in the manner in which the complaint is given, and the wife is made to go to the police station. And as this court is also conscious of the welfare of the children, they need to have the love and affection of both the parents. And this court on the 16th to 23rd and 30th March, for the next 3 weeks, has permitted the children to exercise, for the father to exercise the visitation rights, and directed the mother to take both the kids to the Bangalore club. And also made it clear that the husband should be very cautious and shall not repeat these kind of acts. And that order came to be. And when the matter came up on 2/4/2024, as son's birthday is on 11th April, the court has permitted the father to meet the children. Then later, by an order dated 18/4/2024, this court permitted the father, the grandfather, the grandparents and sister to exercise the visitation rights on Saturday between Saturday 24/2024, between 10:30 and 11:30 PM. Thereafter, the said arrangement, another in continuation of the same, on 25/4/2024, it was continued, and father was directed to pay an amount of 7.5 lakhs as the arrears of maintenance as determined by the Honorable Apex Court. Then by order dated 6/6/2024, the visitation rights, the visitation can happen at the grandparents' place on 8/6/2024, 9/6/2024, 15/6/2024 and 16/6/2024 in the presence of a third party. Thereafter, it was extended on 19/6/2024. Then when the matter came up on 5/7/2024, it is brought to the notice of the court that the husband had made certain defamatory comments on the wife in the Bangalore club. And considering the submission of both the counsels, this court has asked the counsels to file an affidavit in that regard. And if any objections the husband has, the same was directed to be placed on record. This court has also perused the third-party observer's report. It appears that the boy was good during the visitation time and was enjoying. Today, when the matter came up, the objections are filed by the petitioner, wherein all the allegations that are made by the petitioner, by the mother, were denied. And also arguments are advanced with regard to the brother of the wife, that he is still staying, and he filed some, it is stated that the photographs which he has shows that he is still in that house. And he had also relied on a judgment of
Kerala High Court.
huh?
Kerala High Court.
Muhammad
Ashraf
in case of Muhammad Ashraf
Chirangan
versus
Dr. Fatima B.
Fatima B. This aspect of the brother of the wife staying along with them in a span of months, several times, and initially when this has propped up for consideration, at that point of time, an affidavit is filed that he is not residing with them and is residing separately. Now it is a contention of the husband that the brother-in-law is staying along with them. All those issues, this court is not inclined to go into, as those issues cannot be decided before this court. It is always open to the husband to adduce evidence in that regard before the court below. Then coming to the visitation rights, this court, while interacting with the grandparents and the boy and the girl and also the mother, observed that the boy had a lot of affection, boy have a lot of attachment towards the grandparents. Both the wife and husband or the loggerheads, and the husband on several occasions during the course also, this court observed that is very aggressive in nature. This court has also cautioned him not to indulge in these kind of things. When they are asking for the custody and on all these issues that are decided by the court in the welfare of the children, this court is not this court is not dwelling into any of the affairs that are pertaining to the wife and the husband. As far as in the light of several orders passed by this court, and where keeping the interest of the minor in mind, court has looked into several aspects and has given considerable time for the parties and also interacted with the parties several times. And as a main G&WC is pending before the court, considering all this, this present writ petition is disposed of as per the below. One, the the order passed by the court below dated so and so, the trial court, family court is modified. And the, cha- the,
Son
the,
Kevin.
the boy, Kevin, what's his name is Kevin?
Kevin, K-A-V-I-N.
The boy can, the grandparents can exercise a visitation right at their place on every Saturday, on Saturday, and the boy can stay overnight on Saturday and Sunday by 8 o'clock. He shall be brought back to the mother on 8 a.m. 8 a.m. The mother shall drop the boy and pick him up from the grandparents' place.
I will pick and drop.
Huh?
I will pick and drop
Ah.
because they are videographing it. I will pick and drop. What Saturday morning I'll pick, Sunday afternoon, evening.
Saturday morning. Saturday, 10 o'clock, he can be picked up, and by Sunday morning, 8 o'clock, the boy shall be dropped at the mother's place.
So let us say
And
Sunday,
they shall
little-
let her
he
to
will-
the,
He will get up a bit late, child,
Huh?
young child. 8 a.m. he'll get up a bit late, 10 o'clock it may be.
10 o'clock, and the petitioner shall adhere to the timeline and shall not create any kind of inconvenience
Uh,
the party to the respondent. Number two, as far as the girl child is concerned, as she is too small, on Saturday, she can be from 10 o'clock to 12 o'clock,
2 o'clock she was already there.
10 o'clock to
10 to 2 she was there.
10 o'clock to 1 o'clock on Saturday.
And
And whenever, if she wants to stay back, she can stay back. Or if the girl is not comfortable, even
will-
before the scheduled time,
I-
the girl can be sent. Next, the issue with regard to the brother staying along with the wife, the brother-in-law staying along with the wife and the children, that aspect, it is open to the parties to agitate before the trial court.
as prescribed under law, because I cannot agitate before the trial court. That is only with respect to custody. If I have to talk about the safety of the children, then I have a recourse under POCSO itself.
That I am not.
As
GNWC, what is supposed to this court can tell. But whatever remedy you have before
Yes,
other
that-
courts, that
yes.
we need not tell. If you have a remedy,
Yes,
you have a
yes.
remedy. Accordingly disposed of. Even if, no. And in the course of, even in case of boy also, sometimes if whenever he's not comfortable or he wants to go to the mother, that request of the boy,
Yes, yes.
should be honored.
I'll start exercising from tomorrow itself. From tomorrow it's maintenance is already paid even by calculation. Even by calculation, it is paid. 15 lakhs has been paid.
As per the
Yes, I will pay. I am
pending the petition, as per the orders of the Supreme Court, per
I'm
month,
with-
how much is paid?
15 lakhs has been paid.
1 lakh? 1,25,000 is supposed to be
I'm
paid.
paying.
That should be, the father shall continue to pay the
Yes,
same.
that is there. In fact, your ladies,
And if any amount is not paid,
your ladies,
then they can file.
one
execution for that.
request, that 125 Supreme Court had given me liberty to challenge. That is under challenge. Yes,
that is
that may be made
altered.
clear. That may be,
Till further orders are passed in the domestic violence.
no, in the appeal. And domestic
in the-
violence also.
In the appeal, till further orders are passed, 1,25,000, the petitioner the husband shall continue to pay to the wife.
Yes.
And if any default is there, the wife is at liberty to exercise.
15 lakhs has been from, even if we take, there are 10 months. From August to till now, 10 months, I was supposed to pay, that becomes 12.5 lakhs. 3 lakhs was the High Court order, 15.5 lakhs. I have paid 15 lakhs for till the month of April. Then subsequently I have paid for school also. In fact, in the month of April only I had paid till July.
Your lordship had calculated into is made 15 lakhs was the due amount in April, which they paid because they wanted visitation. Thereafter 3 lakhs.
They may file a memo, they may say unofficially, or they can give.
Then we will keep a rider like this. Till the order, till the order is altered in the appeal, every month, every month by 5th of every month, if the amount is not, if the maintenance is not paid to the wife, this order passed by the court with regard to exercising the visitation rights will not be, is not possible for the said month.
Yes, I have no issues. And in fact, if she has anything, she's saying anything is pending, let her communicate. I will communicate to the client.
Yes. Pending is closed.
That pending IA one is amendment. Shall I carry out the amendment?
No, as in view of the, as a disputation is disposed of, all IAs pending in this case are closed. Yes.
Senior is in Hotel 7, my lord. Kindly have it on Tuesday, my lord. It's only for regarding maintainability, whether it is.
Only asked yesterday for today.
Yes, my lord, senior is here on.
Tomorrow, Monday,
Achha.
no further adjournments, yes, in the same caption.
Yeah, for the petitioner, my lord.
Already
filed the acknowledgement along with the copies of the memo
to
the court, my lord.
Mm.
It is served to the respondent advocate in
Yes, sir.
it is served.
Mm.
And the only question arise in the writ petition is, my
No,
lord.
no, what, we will do one thing, what is the name of the advocate? Land counsel of the petitioner as per the order passed by this court has served the notice on the response.
CV Keso Murthy,
One minute, one. And filed a memo to that effect. Sahana MS.
Sahana is the respondent. The advocate name is CV Keso Murthy, Krishnamurthipuram, advocate.
Where do you get that?
I got the name of the person from the trial court advocate. I sent it by RPA email. It is not returned, but I trace out from the computer on the postal receipt, my lord.
Oh, no, what is the advocate name? Please give it. It is submitted that they have sent a notice to the advocate appearing before the court as well as to the party. Registry is directed to print the name of so and so. Post this matter on Monday.
Monday, Tuesday, my.
Tuesday. Yes, next matter. Yes.
For bringing the LRs on record has been filed, my lord. The trial court also, the amended paid and everything has been furnished, my lords. The matter was posted in the year 2019 here, and it was partly heard, and thereafter it was only posted in 2024. As such, we could not file, the petitioner was also senior citizens. Could not get the instructions and file the necessary applications.
Then we'll dismiss this petition.
My lords, for final hearing has to be done.
Huh?
Final hearing.
No, what final hearing? It is at we have to, so many applications needs to be filed in this. Please look at the cause list.
Yes, my lords. To bringing the LRs on record, condonation of delay and setting aside the abatement.
No, the LRs are, you appear for the LRs? For all the LRs?
Respondent number 1.
And who else ought to be served?
Everyone is served, my lords.
So why can't we hear it now?
Yes, my lords. Yes, my lords. That is the submission I made, my lords.
Huh?
That is the submission I made, my lords, on the IAs. Hence, the IAs may be allowed, my lords.
Not the IAS, it's a 2016 writ petition, we'll hear it.
My lords, we have to make the amendment, my lord. The relief
That
has
you
to
can
be.
do.
I may be permitted that, it may be ordered, I mean. We are ready with the matter, my lords. We'll carry out the amendment. IAs may be allowed.
This came up on 27/6/2024. Then that day I said no further adjournments. It came up on 18/6/2024.
It's my lord, it did not reach. The last two dates, it did not reach.
No, it came up with this.
At
They're all the docket
27/6, it was,
proceedings and
yes, my lord, 27/6, it was fault on my part, my lord, that I did not mention about
18/6
the
it has
IS.
come up. Then on 27/6 it has come up. If
Monday,
it reached,
Monday
that's why
itself,
there is a docket. The IA number. The IA number 3 of 2004 is filed to bring the LRs of deceased R1 on record. IA 2024 is filed to setting aside the abatement. IA 1 of 24 is filed to condone the delay of 1014 days in bringing the LRs on record. For the reasons stated, Learned Council submits that they have no objection to condone the delay. Considering the same, IA number 1 of 24 is allowed for the reasons stated in the accompanying affidavit for condoning the delay of 1014 days. And IA number 2 of 24 is filed. IA number 2 of 24 is also allowed, setting aside the abatement. Consequently, IA number 3 of 24 is allowed by bringing the so-and-so, who are they? R
respondent number 1A,
1A to
1C, my lords,
1A to
1C.
respondent 1A to 1C are brought on record as LRs of LRs of deceased R1. Learned Counsel for the respondent V. Sanjay Krishna submits that he has instructions to, he has already filed wakalas for the LRs also. The petitioner shall carry out the amendment, carry out the corrections in the cause title and post this matter on 16th. No further adjournments. Yes. Yes.
Serial number 13, I am for the petitioner, madam.
Yes.
But the sole petitioner is died.
Yes.
And I made LR application to bring the LRs on record to
Yes.
prosecute the writ petition.
IA 1 of 24 is filed to condone the delay of 774 days. IA 2 of 24 is filed to set aside the abatement. IA 3 of 24 is filed to bring the LRs of the deceased petitioner. Then counsel for the petitioner submits that these are the LRs of the petitioners and also reasons
1A
stated for the delay of 774 days. Considering the reasons stated, IA 1 of 24 is allowed by condoning the delay of 774 days. And 2 of 24 is allowed to set aside, is also allowed. And accordingly, what are they now? Where is that? How many are there?
1A to page 17, madam.
1A to
1A to 1E.
1A to, where do you get that?
Page 17, madam.
Huh?
In the LR application.
1A to 1E are treated as LRs of the deceased petitioner. Accordingly, the amended cause title shall be filed. Post this matter for hearing on 18th. Yes.
Yes.
You appear for the respondent. No representation for the petitioner. Post this matter for dismissal on Tuesday. Yes. Monday, 15th. 15th is a FC day. That's why 16th is posted. 16th. Yes. Yes.
Service.
trial court, you appear for the respondent. Respondent number? This is where Mr. M. Rajashekar for R1 and R. Respondent is served.
Now, in view of, I have filed a memo, sub-service by way of paper publication is taken out. All served.
Yes.
And respondent number 8, I have filed memo seeking dispensation of notice.
Where is the memo?
And that is serial number 16.
15 is already adjourned. Hmm.
Notice to respondent number 8 may kindly be dispensed with.
Paper publication dated.
Paper publication may be accepted and
It's already accepted.
no, not yet.
Not accepted. As per the order passed by this court, the petition has taken out notice by way of substituted service on an R6 and filed the paper publication. Notice in respect of the same is accepted, and the notice to R6 is held sufficient. Then a memo is filed seeking dispensation of notice to R8 accordingly. At the risk of petitioner, notice to R8 is dispensed with. Ready?
16th or 18th.
Huh?
16th or 18th.
16.
Please.
4th on 16. At the request of land counts for the petitioner. Yes. Who appears in 17? Your audio is muted.
I appear for the petitioner, my lord. I'm sorry.
Yes, yes.
My lords, if my lords may see order dated 31/1/2024, my lord. In that, my lord, this honorable court had permitted us to serve hand summons to the counsel representing the defendant before the trial court, my lord. My lords, pursuant thereto, my lords, we have filed a memo of having served a copy on the defendant appearing before the trial court on behalf of the respondent. If my lords may see the memo dated 6/3/2024, my lord.
6/3.
2024.
Yes, 31/1. 6/3/2024.
Yes, my lords. In that, my lord, if my lords may turn to page 5, my lords.
Yes.
Page 5, my lord, consists of the acknowledgement of having served a copy on the advocate, my lord. That is Mr. Avinash BC, my lords, from the firm. We have been in constant touch with him, my lord, but however, pursuant thereto, my lord, when we went to serve a physical copy of the entire writ petition papers to him, he refused to take it, my lord, stating that we don't have instructions from the Standard Chartered Bank, my lord. That is, if my lords may see the email dated at annexure Q, my lord, page 7 of the memo.
No, for a bank, now the notice is not ordered through court.
My lords, 3 times process was paid, my lord, but it returned as unserved, my lords. That is why my lords had permitted us to serve it.
No. File a substituted service application. That would be better.
Please, if my lords, there is one more address of the Standard Chartered Bank in New Delhi that we have. We'll furnish that address, my lord.
Petitioner, the notice that
Substituted
is
service, lord.
in the 3 times, the notice could not be served. Petition is permitted to file an application for substituted service. Post this matter on 18th. Yes.
Please, ma'am. Obliged.
No representation for the petitioner for dismissal on 22nd. Yes, next.
For petitioner, my lords, if a direction is issued to the trial court to expedite the matter, that would be same.
After being pending here for 2 years.
My lords, subsequent events.
What is the prayer that you sought?
My lords, to squash the order allowing the wife to file objections to the main petition, my lords. My lords, after subsequent to the filing of the MC case, my lords, matrimonial case. She did not file objections to the main petition for 2.5 years, my lords. And my lords, she filed an application, my lords. And thereafter, my lords, she has moved to Canada, my lords. Till now, she is not in India.
What is the stage?
My lords, now recently, my lords, the case has been transferred. She has moved a coordinate bench to transfer the case from Anekal to Bangalore Rural, my lords. It was transferred, my lords. Now, the case is for evidence of respondent.
Please come. The present writ petition is filed. Questioning the order dated 23/3/2022. Whereby the court had allowed the application filed under section 151 CPC on payment of costs of rupees 2,000. And the respondent is permitted to file objections. The by order dated 15/4/2021. What has happened on 15/4/2021?
My lords, she and her counsel, my lords, not appeared.
Please come to where is 15/4/2021 order? 15/4/2021.
My lords, arguments were heard, my lords, on that day.
No, you filed the docket proceedings. Where is that 15/4/2021 order? On 15/4/2021? As the counsel for the respondent
Page number 16, my lords.
has already sufficient opportunity was granted, objection was taken as nil, and matter was posted for petitioner evidence on 9/7/2021. By virtue of this order, the court had permitted the wife to file the objections and file the objections. Agreed thereby the husband is before this court.
My lords, one more submission, my lords. Despite this order, my lords, she has not appeared before the court, my lords, nor her
It is
advocate is
submitted
appeared.
that even thereafter, she has not pursued the matter. It is submitted that this is an MC of 2019 and the same is still pending before the court below. Considering all these things and as a writ petition is of the year 2022, this court then this writ petition is disposed of, directing the court below to dispose of the writ petition as expeditiously as possible, but not later than 8 months.
My lords, 6
as-
months, my lords, 6 months.
8 months, and this court is not proposing to issue notice to the respondent as the early disposal is in the interest of both the parties. Yes,
Achha.
yes, next.
For challenging the interim maintenance matter passed by the trial court, my lord.
What is the order?
My lord?
What is the order? What is the order impugned?
For directed me to pay the 20,000, my lord, 10,000 towards the maintenance and 10,000 towards the treatment of the training of the child. They are taken defenses that the child is handicapped, but they are not at all produced single documents, my lord.
You deny that fact that child is
Yes, yes,
handicapped?
definitely, my lord.
Uh,
And they are taking defense, my lord.
What is your income?
They are taking defense, I am getting more than 23,000. But I am producing salary certificate, my lord, from the past 3 months, 5 months. I am getting just 28,000, 26,000, 33,000. but my mother is also depend upon my salary. And my one younger brother is also depend upon my salary.
When
He is also physically handicapped.
When is this petition filed?
On 3rd March one.
3rd March.
Petition filed.
No, this petition for maintenance, when is it filed? Date of petition.
Two 2022, my lord.
Date. Twenty-one, six.
21/6/2012.
Pay 10,000. And arrears. Then consider the petitioner submits that the court below had granted 10,000 to the wife and 10,000 to the child. His income, his salary itself is 26,000.
Yes. My lord.
Your salary is 26,000.
28 and 26. Yes, 26, my lord. Depend upon various.
So 20 is
Yes.
26,000. It is submitted that he has a old age mother and a handicapped brother to be taken care of, and the court below, without considering all these aspects, had taken the all these aspects had granted the maintenance considering the submission of the learned counsel. It shall be stay of all for the proceedings on the condition that he shall deposit, he shall continue to pay an amount per month at 2,40,000 within 4 weeks from the date of receipt of the copy of the order. If either of the same is not complied with, the appeal shall stand dismissed without further reference to the court. Next, the petitioner shall take out notice on the counsel appearing before the for the respondent before the court below by 30th of July, and shall file a memo by 30th of July and post this matter on 14th. Yes, next.
One submission, serial number 12 interim order may kindly be extended, my lords.
Serial number 12, look at it. If interim order is there, extended.
Obliged, madam.
Which one? Dismissed? No, 12. 12. 12 or 14?
12 minutes.
Ah.
Well. Mine is 14, my lord. I was held up in another court. I rushed to this court, my lord. By that time, the matter was urgent. May kindly be extend the interim order. Since last 2 days it is repeating, my lord, it has not reached. Therefore, interim order may kindly be.
It is all not the problem of the court. If it is not reached, if it is reaching today, court can only call the cases and whoever is there can.
At the time, my lord.
14th. If interim order is there, extended.
Last 2 days, my lord, it is not been extended. That's all my submission. Last 2 days, it is.
If it is not reached, not necessary. If the matter is not reached, it need not, only it is till the next date of hearing. If the matter is heard, then only it will be. So today it will be.
Yes, it has been reached today. Sorry,
Yes.
I was held up.
Yes,
May kindly
yes.
extend the interim order.
Yes, next. Delete from the caption dismissal. Yes,
Extended, my lord.
yes.
Much of.
I appear for petitioner, my lords. We have
21.
Please. We have challenged the order passed by the family court, design number 2, with respect to the maintenance, my lords. The maintenance.
Take out notice.
25.
Notice
Please,
to the
my lord.
respondent. Pose this matter on 25th. Counsel for the petition is permitted to take out notice on the counsel for the appearing before the so and so, and shall file a memo to that effect. Yes, 22.
Yes, my lordship, I'm for the petitioner in this lordship. I'm challenging the order passed by the trial court regarding the maintenance, your lordship.
Enhancement.
No, my lordship. Decreasing. I'm for the husband, your lordship.
No IA is filed.
No, your lordship, I'm seeking for the interim stay of the order, your lordship.
Yes.
The order passed by the trial court is at page number 63, your lordship. The order is
How
for
much is the maintenance?
6,000, 3,000 for the wife and 3,000 for the child, your lordship.
What is your income?
my income is 12,000, Your Lordship. Only contention, Your Lordship, is that I'm okay with the order passed by the learned trial judge for the child maintenance. 3,000 I'm ready to pay, Lordship. But the point is, Lordship, her wife, that is the respond number 1, is working. And she is earning a salary of rupees 8,000. Which fact was also been established before the trial court. That fact was not considered. The relevant paragraph, Your Lordship, is at page
No,
number 60.
even if that is considered also, then
Yes,
how much you are supposed to pay 5,000?
Lordship, 3,000 for the child, I'm ready to pay, Lordship. That is the only barrier what I'm facing. I'm a Swiggy delivery person. I'm working as a Swiggy delivery person. So I'll be getting 12,000, Your Lordship.
No, you are getting 12,000.
Yes,
And wife is getting 8,000.
Yes, Lordship.
If you give another 5,000, it will be equal.
Lordship, that will be a burden for me, Lordship. That is the only problem. And I have to take care of the old mother also with me. 3,000 for the child, yes, Lordship. As I'm duty bound, I'll be paying to that. Only concern is that as she's working.
Also, the petitioner submits that the court below had granted 6,000 maintenance, 3 to the wife and 3 to the son.
Yes, Lord.
His income is 12,000. And in the case that the wife is earning an amount of rupees 8,000 per month. And the court below had failed to consider all these aspects. Considering the same, they shall be stay of all further proceedings on the condition that he shall continue to pay 3,000 by 5th of every succeeding month. And when is the petition filed?
Your Lordship, petition is filed in 12/9/2023.
12/9.
2023.
The petitioner shall pay the arrears. Are you paying 3,000?
Yes, Lordship. As of now, I have not paid. The order is passed on. The order was passed on.
30 towards arrears.
Yes, Lordship. I'll do that.
1,000 shall be paid within 4 weeks. Same in the earlier order, whatever is the date given, but to take out notice and the listing also before that. Same.
That's
Yes, 23.
Grateful, Your Lordship.
Yes,
Partly allowing the maintenance part, the 10,000.
you are the wife or husband?
Wife,
Take out notice.
stay also,
Notice.
stay also sought.
Why?
He is harping to go on with the matter without paying the maintenance and the school fees.
So will not stall. Take out notice, whatever order to be passed will pass. Petition is permitted to take notice from the council. Dates in 21.
Let
whatever
the other
date is
formality take, but not lead the evidence. Because
That's so we can't stay.
without paying the maintenance.
Let the other side come, we will see. Yes.
Date may be
It will
given.
come on 22nd, not 14/8. 25/7. By the time you serve the notice and file a memo on the council appearing for the respondent. Yes, next.
Petitioner in this case, my lord. For petitioner in this case, my lord.
Wife or husband?
Our husband, my lord.
How much is granted?
20,000.
What is the income?
30,000, my lord. And
How
also
much you will pay now?
He's ready to
But
pay.
if he pays 5,000, stay will not be granted. Please come. When is the petition?
25 to 22.
25 to 22. That means plus 24 plus 5 months, 29 months. 29 into 10, 2,90,000. The agreed with the order passed by the court, where the court had granted an amount of rupees 20,000 to the wife and child, or only wife?
Only wife.
Wife, the husband is before this court. Then counsel the petitioner submits that the husband income is only 30,000, whereas the court had directed to pay an amount of rupees 20,000. Considering all these aspects, they said we stay of all further proceedings on the condition that he deposits an amount of 10,000 by 5th of every succeeding month, and arrears at for 24 months. For 29 months. Arrears at 29 months, 2,90,000. To be paid within 4 weeks from the date of receipt of the copy of the order. Either of it is not complied with, the stay stands automatically vacated. They shall take out notice on the council appearing before the court below and shall file a memo to that effect. Post this matter on 14th of August.
Much obliged.
Yes.
Husband's 30,000 is granted. We every month to be paid. Lord, this order to be effective from April, because petition was filed in April 2023.
April 2023.
23. Order is passed in
Now it
February.
is almost 12 plus.
Now he has, in fact, voluntarily been paying 20,000 from December onwards. He has been paying because
No, it is like this.
by account transfer. Earlier he was
No,
paying.
1 minute.
Please.
Now 12 plus this 3 months. Total is 15 months.
Oh, yes,
Total is
yes,
15 months.
yes.
And now court has granted 30,000. How
30,000.
much is the income of the husband?
Husband, there is a, actually after they were, both of them were abroad in America, etc. After coming here after the cases, etc., he has lost the job. He has actually lost the job. Wife is also working, but we are not able to prove it. That is a question of trial, because the cases now presently has lost the job. And
Anyway, you are paying the 20,000, continue to pay till
it
they
is
come.
because when the honorable family judge called, he said, I am going to pay. That's in December. The documents were produced, page 129.
No, what we do is, the arrears, we'll calculate it 20,000 into 15 months, 20 into 15.
My lord, this areas April to December is the, whether she is liable to pay or not is the question which the honorable court.
What is that?
From April to December, till
It is from the date of petition.
from the date of the petition, that is ordered.
It has to be that. Generally, we calculate the arrears like that. So if you calculate whatever you have paid, excluding that remaining you pay. What are you saying that you have paid 20,000?
20,000 from December he has paid.
From December to?
2023.
Till now you are paying.
Till now he is
So then an application is from now 4th month to 12th month, 8
paying.
months.
12th month.
8 into 20,
That the honorable court may reduce it because it becomes about.
1,60,000.
That the honorable court for the present, the honorable court can make it 50%, 15,000 for that period. For the period from up to December.
No, anyway, you are paying it. Why should the court
I leave it.
reduce it to 20,000 and 15?
I leave
So
it.
it is submitted that the court below had granted maintenance at 30,000, whereas though he was working earlier in US, no, yes, at present he has no job. And also the wife is also working. That aspect was not considered. It is submitted that from December 2023, they have been paying the maintenance. And December 2023, they have been paying the maintenance of at rupees 20,000. Considering all these aspects, this court deems it appropriate to grant stay of all further proceedings on the condition that the husband continues to pay 20,000 by 5th of every succeeding month. Then coming to the arrears, it is stated that as the petition is filed in the month of April, and from December, it is stated that they are paying from for the 8 months, 1,60,000. The 1,60,000 shall be paid within 4 weeks from the date of receipt of the copy of the order. Same petitioner shall take either of it is not complied with the stay granted by this court stands vacated. Petition is permitted to take out notice on the council appearing before the court below and shall file a memo to that effect. Post this matter on 14th August.
Please, great.
Yes. Yes, 28. No representation for the petitioner. Post for dismissal on 16th. Same order. Yes, on Thursday, dismissal. No representation on behalf of both the parties. Which case? 30?
I'm for the petitioner in this case, my lord. I'm
31.
challenging the order. Yes, my lord.
31.
Yes, my lord.
Yes.
My lordship, I'm challenging the order of the impugned order stated by the family court, my lord. In this 3/1/20, it's only about the child, my lord. Child is residing with the husband side. Child is almost 14 years old, my lord. Child is with me. I'm husband side. Child is with me, my lordship. And now they have interim, I mean, they have got a impugn order stating that within the 88 days of the impugn order has to be with the respondent has been stated in the order. my lord. I'm challenging that
Impugn order?
there is already interim order being extended. Interim order already is there, my lordship, in this case. So I pray time for the seniors
No,
and
no, no.
other.
Why
court, my
should,
lordship.
nothing, when the matters are listed, you have to argue.
Please, my lordship.
2022, you're enjoying, what is the interim order? Petition is directed to return the minor child to the custody of the respondent within 8 days. What is this?
The respondent is entitled for the cancellation of this.
What is the age of the child?
14 years.
14, boy or a girl?
Girl, my lord.
Staying with father?
Yes, my lordship.
No, staying with father from how many days?
Pursuant to the, just before the order passed to the family court. Before the family court, the divorce petition is pending. An application, the minor child was in custody of the mother respondent. An application was filed, whereby he had sought custody of the child. But the learned trial judge, family court did not grant custody. Our visitation rights was granted. He was implementing that order. However, in violation of the trial court's order, he took away the custody of the child. As such, I filed an application annexure B to cancel the previous order of visitation rights. On that application, the learned family court has passed this order, allowing my application by cancelling the visitation rights also, which was granted in favor of the father. And the custody is now directed to be handed over to the mother. There is an order,
Lordship, she's already.
When? It has to be heard.
Lordship,
When?
I pray time for it.
When?
Next week, my lordship.
Pose this matter on 22nd,
Great, my lordship.
22nd.
Yes, my lordship.
Yes. You are for the respondent? No, on the last occasion when this matter came up, shall serve.
I have submitted documents.
You filed your objections to this?
Well, I have not filed objections,
Then we
my
have to
lords,
take it as it is.
because I have also challenged that order, my lords.
Not order,
Please, my lords.
about the 3,000 and all documents he has filed.
Yes, my lords, for a moment, I will take my lords to these documents, what they have relied upon. My lords may kindly turn to page 1, my lords.
Page number
1, my lords.
1 of what he has filed.
What he has filed, my lords.
Hmm.
It's, that is for a period from 1/11/2020 to 9/12/2020.
Hmm.
Yes, my lords, for a moment. 1/11/2020 to 9/12/2020, my lords.
No, I'm looking at something like 26/11/2020, 4/12/2020.
This is a copy what you saw to me, my lords, which I'm.
Typed copy is there at
Type-
page number 4.
My lords, before going that, my lords, we'll go to page number 1, my lords.
Hmm.
That is 1/11/2022. The statement, my lords, statement from 1/11/2022, 9/12/2020, my lords.
Hmm.
And the next, my lords, we don't see from which the statement is, because my learned friend doesn't have, he may have given me a legible copy.
What, if I remember, on the
Yes, my
last
lords.
occasion he was submitting that, you have contested for,
Election, my lords. Yes, my
there,
lords.
what is that document? Please show. What he says in the affidavit? Page number? Royal Enfield, Ertiga car, Honda Activa,
Yes, my lords. Let it.
2 crores.
Yes, my lords. Yes, my lords. Let him file it, my lords.
Property
My
tax.
lords.
What is the income? What is it?
My lords.
1,27,806.
My lords, for that purpose, I will take my lords, sorry, I will interfere, my lords, before my lords come to some conclusion. My lords, what is that, my lords, they got misinterpreted. That states, my lords, details of movable property to be declared that details of measurement and properties which are in the name of joint ownership. But it's not in the joint ownership, my lords, it is in the name of the father of this petitioner, my lords, where I've got the document. My lords may kindly see the document.
Give away
my
all
lords.
that. We will look at details of the movable property.
Yes, my lords.
What is the amount that is lying with you?
My lords, that's not the amount, my lords. That's not that, it's all belongs to that, vehicle and all those.
First column, please look at.
Yes, my lords, 1,27,806, my lords. Yes, my lords, this is a statement, my lords, for a moment, my lords. I'll take my lords to say that.
No, a person.
Yes, my lords.
No, a person who is, who gets an income of 3,000.
Yes, my lords.
Can you own all these?
It's
It is
not
your
his
self-
property, my lords, it is his father property. All these documents are standing in the name of
Property.
his father.
Not the property. Vehicles also belongs.
Vehicle belongs to the father, my lords.
If vehicles belong to your father, in your statement, why should you disclose all?
My lords, that is the mistake what he has did, my lords. It because while he was filing the nomination, one of that
So now we have
stated
to
that
say. no,
joint
we
name,
have
so
to
he has
say now,
declared that, my lords. I got the document to show that.
Court has to say that.
Yes, my lords.
No, all this, what you have stated, so in your, while contesting the election,
Yes,
it's a wrong statement.
It's not a wrong statement, my lords. That
It is not a
interpretation is
wrong
this, my
statement.
lords.
It's also not a correct statement.
My lords, what they say is in the joint names. He thinks since it is a property belongs to my
No,
father,
please
so.
please come, where did they mention about joint in Kannada? Joint, where did they say, please tell?
Yes, my lords, I will take my lords to that. Page 7, my lords at 8, my lords. 8. ನಾನು ಈ ಕೆಳಗಂಡಂತೆ ನನ್ನ ಪತ್ನಿ, ಪತಿಯ ಮತ್ತು ನನ್ನನ್ನು ಅವಲಂಬಿಸುವವರ ಆಸ್ತಿ ಅವಲಂಬಿತರು ಎಂದರೆ ಅಭ್ಯರ್ಥಿಯ ಆದಾಯದ ಮೇಲೆ ಬಹಳಷ್ಟು ಅವಲಂಬಿತರಾದ ವ್ಯಕ್ತಿಗಳು.
No, you don't have to read it
Yes,
read it out. Tell me in English what it is.
Para number 8A. Details of the mobile property matter in the name of a joint.
No.
But mention it that, mention it the name, the property is standing with whom name.
No, that column is pertaining to joint property.
Yes.
So it doesn't matter. But what about money?
Money, my lords, as on that date.
You will not, you can't say that joint property, joint money.
Yes, my lords, that was transferred from my father, my lords. That's what I wanted to put forth, my lords, because in my assets and liabilities,
So what is the maintenance granted?
20,000, my lords. My lords, my kindly took.
No, please come to the order. No, just leaving that at that point. Please come.
My lords,
Kindly come to page number 29. Photograph of the house
20?
matter, 29.
There are 2 writ petitions, right?
Yes, my lords.
Page number 29.
20?
9.
Yes. This is the house, sir.
Kindly come to the page number 31 to 36, which is the transaction.
Yes, my lords, I will put forth. my lords.
1,75,000.
Yes, my lords.
And 40,000.
Then we'll do one thing. We'll set aside this order, all these material and all. It's a matter of the court will conduct it, then you will be more benefited with this. We'll set
Yes.
aside this order, let him continue to pay the amount till that is decided. We'll fix your time frame.
Now, okay. That's it.
No,
My lords,
whatever is.
that is, my lords,
That one also not.
let him make. My lords, to this, my lords, whatever photographs he has showed, my lords, page 29, it is a joint family property. There are more than 64 people, my lords, who are residing in that house. There is no partition with respect to the family. And he himself has produced the RTCs to show that the entire properties are in the joint family. And there are 8 co-participants, my lords, 5 males and 3
How
females.
much
There
is
is
this
no
court,
partition.
directed him to pay?
20,000, my lords.
This court.
No, this court directed me to pay 5,000.
You have paid?
I'm paying regularly, my lords. And even that amount is paid my father, my lords, because I have to agree, I have to, yes, my lords, I do agree, I make a open statement, not because, yes, my lords. Because I don't have income, I have to bow down my head to this court. I'm paying because, my lords, even that 5 lakhs won on the last occasion, my last lord asked, that's a statement where my father got transferred, which I produced with the additional statement that was transferred by my father to my account, and that was paid to her studies before the marriage itself, my lords.
Yes. The IA number, the agreed by the order passed in IA number 1 and IA number 1 or 2 this?
This is a one, my lords, IA 1 is for maintenance. IA 2, they have sought for legal expenses. Court has, without discussing anything, court
And
has
the
ordered
order passed
20,000.
in IA number 1 and 2. The court had, the order dated,
Let's order dated.
19/1/2024.
Yes, my lords.
The court had granted maintenance of an amount of rupees 10,000 to the daughter and 10,000 to the wife, and the legal expenses of 20,000 to the 20,000. It is a case of the wife that she is unemployed. She is taking shelter in her parents' house. And she required at least 1 lakh per month to meet her expenses. The petition, the husband has filed his objection stating that he's working as Gram Panchayat member and earning rupees 3,000 per month. The wife had refused to leave the marital life and settle at Jagalur. The court has considered the judgment of the apex court with regard to the maintenance and the permanent alimony.
With respect to the assets and liabilities. my lords.
Not
Assets and-
considered.
Not considered.
And had granted the maintenance. Land counsel for the agreed thereby, both the husband and wife have filed 2 writ petitions. The husband's writ petition is numbered as WP 13021 of 2024, and the wife's application is numbered as WP 8418 of.
My lords, sorry, my lords. The first petition is
Did
by
you
the
watch the,
wife, and the
Her
second
wife's
petition.
petition is numbered as 13021 of 2024, and the husband's petition is WP 8418 of 2024. Then counsel appearing for the husband submits that he's not, he's having, his income is 3,000, and the properties or all that mentioned are joint family properties. And now by way of the interim order, this court had directed the husband to pay 5,000, and that amount of 5,000 is also being paid by his father, and he has no means to maintain himself. And counsel for the wife had filed certain documents before this court stating that the husband is having a lot of income, is getting a lot of income, and also in the election, while he was contesting for the election, in his declaration, he has stated about the properties as well also his cash deposits as 1 lakh and all these things shows that he is having more income, and he has come before the court with suppression of facts, and the wife requires maintenance, and the wife is he has filed the photographs also showing that he owns a very big house, and the wife and the child needs to live as per the standards of and the lifestyle as the husband is leading. In response to that, land counsel for the husband submits that it's a joint family property. There are so many co-partners, and there is no independent income more than this 3,000 to the husband. Considering all these facts, this court is of the view that the evidence that is placed before this court, which this court cannot appreciate while entertaining this writ petition under 227. Hence, and also this court finds that the court, while granting the said to compensate the said maintenance, has not properly appreciated the assets and liabilities or any of the, what is the income of the husband. All these aspects were not considered by the court. Hence, the order and the revision, the order impugned is set aside, number one. And the matter is remanded back, directing the court below to consider the application afresh by after the assets and liabilities and the relevant documents that the petitioner, that the respondent, that the wife is relying on, and shall decide the same within a period of 2 months from the date of receipt of the copy of the order. By way of an interim order, this court had directed the husband to pay an amount of rupees 5,000. The same he shall continue to pay till the further orders are passed by the court. Huh?
No, sorry, my lords, because he doesn't. Yes, my lords. I do agree, my lords. I do agree. Whatever.
No, once that is there, you will get it. You will get it from the date of this thing. Continue to pay 5,000. Yes, and accordingly, both the petitions are disposed of. Next. Yes.
They have not served the copy of the petition.
ಕೊಟ್ಟೆ ಬಂದು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ರಿ ಕೊಟ್ಟೆ ಮೇಡಮ್ ಕೊಟ್ಟೆ ನಾನು ಬೇಡ ಅಂದ್ಬಿಟ್ರು
ನಾವು ಕಮ್ಮಿ ಕೊಡ್ಬೇಕು.
ತಾವು ಈಗ ಬಂದಿದ್ದೀರಾ ಪ್ಲೀಸ್ ಇಂಟ್ರಿ ಮಾಡಲ್ ಕಾಪಿ ಇಸ್ ಕಂಪ್ಲೈಂಟ್ ಅಲರ್ಟ್ಸ್
They have paid.
ದೇ ಪೇಡ್ ದಿ ಮನಿ
50,000 they have paid.
as per the term of the order.
4,000 interim maintenance they have not paid.
No. What is the order?
Interim order was there 50,000 and every monthly I have to pay. That I will pay that 4,000.
No. Both of you are here.
Please,
So what
okay.
is the impugned order? Why we can dispose it off?
The impugned order was there, your lords.
Oh.
The only question that were before the court below,
Hmm.
the asset and liability statement was not filed by me.
By both the parties?
No,
Or
no,
by you?
they had filed.
You are for the husband?
I am for the husband there.
Ah.
The interim or the asset and liability was not filed
Why you are not filed?
because the reason was not there. Assigned was I sought some time to file the asset and liability. That, please, your lords, my order copy has been produced before the court.
Where is the impugned order? The
Impugned
respondent
order,
is
lords,
hereby
may
ordered
kindly,
to pay
please, your lords.
8,000 per month to the petitioner as interim maintenance. Deposit the arrears from the date of this order. Now, this order is assailed before this court.
Yeah, please, that this order is assigned before.
What is our interim order passed by this court?
Interim order was there. I should pay 50,000. I have paid that by way of a demand
Now,
draft, yes, ma'am.
What is your
Which I'm
income?
going to pay another 4,000 I have to pay, I will pay that amount.
What is your income?
My income, I don't have any job. I'm a jobless.
Then why you should have filed your area, the statement of assets and
No,
liabilities?
that is what I had sought time, the details there.
Let him continue to pay that amount and will let him file that and court shall dispose of. In the meantime, he will be paying that 4,000 as ordered by.
Yeah, please, that order I'll
Please
keep on
come.
paying.
The present writ petition is filed. Agreed with the orders passed in I number 2 in MC number 7691 of 2022, whereby the court below had directed to
Not I
deposit
have
the.
complained the order, please.
Huh?
Memo, I'm filing a demand draft,
Ah.
copy where I have filed.
Take that, to directed to pay maintenance at 5,000 and also the arrears within 2 months from the date of the order. When agreed thereby, the husband is before this court. When this matter has come up before this court and it is stated that he is not having any income and court has directed him to pay 8,000. Considering the said submission, this court had directed the husband to pay maintenance of an amount of rupees 4,000 per month by 5th of every succeeding month, and also to pay an amount of rupees 50,000 towards past arrears within 4 weeks from the date of receipt of the copy of the order. Today, a memo is filed before this court stating that the amount of rupees 50,000 is deposited by the husband, which the respondent wife is entitled to withdraw the same. No.
Yes, sir. Let's keep it clear. They have got
Correct. Now, let him come up with that, all that, whatever you want to file before it, it is left it open to you. Whatever additional documents also you want to file, you file. The wife is at, huh? Wife is at liberty to pay.
Now, not please, let it be 4,000.
My wife is at liberty to withdraw the same. Learned counsel appearing for the petitioner submits that the husband could not file his assets and statement of assets and liabilities. Learned counsel for the respondent submits that in fact he wants to file an objection in this writ petition showing that he is having he is having immovable properties. It is submitted that the
Immovable property is the name of the mother. That's what he
movable
wants.
properties and the court in fact has not granted the compensation as required, but only an amount of rupees 8,000 is granted by the court. This court has perused the order and the submission of the learned counsels on either side. There is no dispute about the fact that the husband had not filed his statement of assets and liabilities. Now it is a contention of the wife that there are several documents to show that he is having immovable properties. Considering all this, the order in the revision, the order impugned before this court is set aside and the matter is remanded back to the court below. Number two, both the husband as well as the wife can file their respective documents along with the statement of assets and liabilities. Basing on that, the court shall consider the application within 2 months from the date of receipt of the copy of the order. Till such time, the husband shall continue to pay 4,000.
It's much of it. No.
Let it be 1,000 out is paid. Yes.
If I may pray for my lord's indulgence, my lord, my apologies to interrupt, my lord. My lord, serial number 17, my lord, interim order has to be extended, my lord.
Serial number 17. If interim order is there, it will be extended. Yes.
And my lord, if the matter has been fixed on 18th, my lord, if may be taken up on 22, please, my lord.
How can these kind of requests be entertained, Mr. Counsel? Please understand in between.
My apologies, my lord.
How is it now that that stenographer who has taken is also not here?
Please, my
Oh, instead of
apologies.
18th, give it on 22nd. Yes.
My apologies.
Yes, next.
And but the petitioner.
Yes.
Right, as per the decisions of this honorable court, the disabled petitioner before this honorable court is handicapped. Your lordship directed me to keep present.
Matter.
My lord, on 10/7, my lord, you have filed photographs and other documents with additional affidavit.
No, this is a OFC matter.
Yes, madam.
Maintenance.
Yes.
You said he is handicapped, which was denied by you. So, you see.
Your client, his client also, my lord, BA.
No, please tell the court, how much is the maintenance granted by the court below?
10,000.
What is his income?
His income, my lord, it is 1 nimsha. Don't pressurize the court, sir. See, there are assets and liabilities filed by both parties. My lord, can you see, yesterday I filed.
What is the income of the wife?
My lord, more than 27,000. She has not produced the salary certificate before the honorable trial court. But she proclaimed only, my lord, 14,000. 14,000. Then, my
Husband's
lord,
income?
his income is 58,000 and add, my lord, out of which, my lord, 46,800 is the expenses, monthly expenses for his age-old alien mother and elder brother who is a mentally disordered person. They are two depending. My lord, he is also, my lord, he is wearing pant. Therefore, my lord, we produced 4 photographs on 10/7, my lord, in order to appreciate whether I am correct or the other side is correct. He went on making allegations against a disabled man. He's incorrect. She is happily, my lord.
Why would he make whatever
Correct.
his
She
instructions
is happily
will
living,
submit?
she is living a luxurious life. She don't want to produce the salary certificate. She is a teacher.
Child is there? Only wife or the child is also there?
Child is not ours, my lord. There is the biggest complaint. if your lordship required to let me produce, she has been, my lord, stolen the child from Vanivilas Hospital, Victoria Hospital. There are so many complaints are there. She is facing criminal cases.
She is not facing any.
Yeah, ಇದೆ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಬೇಡ, ಅಮ್ಮ ನಿಮ್ಗೆ ಹೇಳಲ್ಲ. ಯಾರ್ದೋ ಮಗು.
Because trial is already completed with the trial court.
మేడం, మహిళ ఎవరో బిడ్ని దొంగలించుకొచ్చి ఆడుండే వాళ్ళతో జత చేసుకొని దే ఆర్ ఫేసింగ్ allegations. Here,
Anyhow, we'll not go into all that. Let's, please come to the
Yeah.
order.
under the
Please come to the order. Order impugned.
RTI, my lord, we got all the documents.
Order impugned.
The client has stolen the child. ನೀವು ತಪ್ಪು ಒಪ್ಕೊಳ್ತೀರಾ? You never pleaded guilty. My lord,
You were married?
my lord, on 10/7, my lord, I got produced so many documents along
No,
with.
when is the date of marriage?
Your lordship says, the honorable trial court also rejected the maintenance to the said Raghavi, the child, who has been adopted by the respondent wife.
Respect of the maintenance to the wife, the order is fair honor.
14. Annexure A, my lord.
Marriage is solemnized on 12/11/2014.
No, where did the court discuss about your salary?
In the order, my lord. It is at 6/2, because I am not received the.
My lord, kindly go to page number 18, internal page 5 of the interim order, my lord.
5, huh?
Yes, ma'am. Your lordship may kindly see. Petitioner is getting, after all deductions, the net salary of rupees 58,250. But my lord, at the same time, I would like to invite my lordship to assess some liabilities filed by the, I will, my lord, can you see annexure,
Page number you can refer to.
annexure F, my lord,
Hmm.
page number. Annexure F, J, my lord. Annexure H, my lord. Ink page, my lord, can you see ink page 64, my lord. Column 2, my lord, please. C, head note C, column 2. Monthly house rent 18,000. Monthly house maintenance for food, so and so grains.
No,
15,000.
you're reading at 60?
Then, my lord,
You're reading at?
I declare, my lord, INR. Page
No,
number
no, you're
60
reading at which page? 60?
64, my lord.
Huh.
Then, my lord, 65, lordship may kindly see in the bottom portion, name of the employer, designation, monthly income, 58,250. In page number 64, my lord, I have clearly disclosed what are the expenses and maintenance of my mother and as well as my mentally retarded brother. It comes to, my lord, 46,800. I am getting only 58,250. My wife is getting more than 27,000. She did not disclose the salary by producing the salary certificate. She is a school teacher.
Where from, what is happening for that amount, 48,000?
My lord, I have clearly mentioned in column 3, my lord, in page number 64, 18,000 rent, my lord.
18,000?
Rent. 64, please.
Where do you get that rent, 18,000?
Uh,
So
my-
your rent is her salary, her whole
Well, I am
money
paying
is
rent,
that.
rented house, madam.
Where is she staying?
She is staying somewhere. She is drawing more than 27,000. But I have no money because I am getting 58,250 and the expenses is 46,800. I have to maintain my age-old aliened mother.
Wife also you have to maintain.
Definitely. It is not denied by
So the
law.
court has also understood that.
It is law also not denied.
Hmm.
My lord, kindly see the photographs which I produced. My friend saying that he is not at all having any trouble. Therefore, my lord, your lordship directed me to, keep present the petitioner before the court. And my lord, I have not produced the photographs. I don't know whether the documents which I filed in the office is put up or
The
not
photos, yes,
with affidavit.
please come. What do you say?
I am able to pay my lord only 3,000 to 4,000 because he is getting my salary.
No, again, the lower court also observed about the.
It
child.
is not our child, sir.
That we will see.
Trial court also very clearly said.
Because the salary certificate that he has produced was of year 21 or 22.
Always the court speaks about the able-bodied person in all the judgments. Strict the sense. No, the wife is also well educated.
B.Ed, my lord.
I have filed the execution petition also.
Please come.
About 3,70,000 is.
That you can recover whatever like till the other order is passed with this court, whatever are the arrears. The agreed with the order passed in I number 3 under section 24 of the Hindu Marriage Act in MC number 1902 of 2020, dated 26th day of May 2023. The petitioner, the husband is before this court. It is the case of the wife that the petitioner, the disputes have arose between the parties and the petitioner, the disputes arose between the wife and husband, and the husband had disputed the paternity of the child. It is a case that is drawing a salary of 52,000. Salary of rupees 58,250. The salary of the wife is 14,000. The wife, the husband is having several properties. And with that amount, as she's not able to maintain herself, and it's the duty of the husband, she sought for maintenance of an amount of rupees. How much is sought? How much is the maintenance sought?
35,000.
30?
35,000.
And a maintenance of rupees 35,000 is sought. When I agreed thereby, the husband is before this court. When this matter came up on the last occasion before this court, the counsel for the petitioner has disputed, the petitioner has submitted that the husband is a handicapped person, which was disputed by the respondent. Then counsel for the petitioner submits that today, the petitioner is before this court, which shows that he's a handicapped person. He submits that he's having a mentally retarded brother and also of aged mother to take care of.
74 years.
74 years. The qualification of the wife is?
B.Ed.
B.E.B.Ed.
B.Ed. B.Ed, madam.
B.A.B.Ed.
B.Ed, somebody.
B.E.
What they have,
Bachelor in Litigation.
B.B.Ed. And the qualification of husband is?
B.M.B.A.
B.E.M.B.A.
Both are same, madam. Equal graduation.
B.M.B.A. And as the wife is equally educated and also physically more stronger than is in a better position than the husband. she could have, the court below ought not to have directed the husband to pay maintenance of an amount of rupees 10,000. Land counsel appearing for the respondent submits that, respondent wife submits that the husband, the wife is alone taking care of the child and taking care of the child. The husband is in fact is drawing more than the salary as stated, but as though he's drawing more than 70,000, only 58,000 is shown as the salary. Even if 58,000 is taken, there's still as considering the income of the wife, he has to support her and pay the maintenance. Next one, considering the submission of both the parties. There is the material on record. There is no dispute about the fact that the husband is a handicapped person. And both of them are equally educated. According to the husband, he has a mother and a mentally retarded brother to take care of. According to the wife, she had to take care of a girl whom she has adopted. Considering the case of both the parties, this court deems it appropriate to reduce the maintenance from 10,000 to 5,000. Accordingly disposed of.
Matches.
No representation, post for dismissal on 23rd. Yes.
My lord, whatever the address is mentioned in the trial court and this case, both are same, but still the notice is not served.
No, first of all, we are on notice.
Yes, still it is not served, so.
You have to serve notice.
Yes, so we'll take the substitute service next.
What has happened earlier?
It's not served. Notice is not served.
You paid the process.
We have done.
So no, it is written with an announcement unserved. Petition is permitted to take out notice by way of substitute service. We shall come up with an appropriate application. Post this matter on 25th.
Yes, next date we'll file IA.
Yes, next. All the details of that is. A memo of retirement is filed stating that on 28/10/2022, the party has taken away the papers and also acknowledged the receiving of the papers. The copy of the no objection is also filed before this court. Yes, delete the name, and accordingly, the advocate is permitted to retire. Print the name of the party. Post this matter on 18th. Yes. Yes. Yes, no representation for dismissal on 23rd. Same order. You appear in 40?
Withdrawal.
You want to withdraw?
Yes. Memo of.
Take that.
Memo of withdrawal.
Give it. MOA is filed seeking to withdraw the writ petition as non-press. It is, the memo is filed stating that the matter is settled before the mediation. Hence, writ petition is maybe permitted to withdraw accordingly. This memo is taken on record and dismissed as withdrawn. Yes, 41. Yes. No representation for dismissal on 18th. Direction for transferring
appear
the
for-
NC number. Yes.
My lord, appear for the petitioner, but we never moved any petition. This petition is already disposed of. And then we never sought any direction,
What
but
is this petition?
my lord would recollect.
Uh,
My Well, I would recollect that court had directed my cross-examination to be completed initially in 3 to 4 dates of hearing, and thereafter by subsequent order, it was extended for another 8 dates of hearing.
For the wife for 8
It
years.
is that matter.
Then conclude cross-examination. The Honorable it is ordered that the court shall endeavor to cover the proceeding. It's not a, but it's good at each state. The litigant for the petition filed a written submission. So and so has passed an order to place the records in MC number. These cases to some other family courts in Bangalore. To another court by exercising administrative powers as vested in. There is a judicial order passed by the Honorable Island by so and so. How come these kind of things can be power sent on judicial side?
Yes, my lord.
This letter. Just send it to the Registrar General. Was this matter on Monday? Yes, 43.
My lord, may I request, my lord, we have from Bombay, there is another list of connected matter on 22nd of July. Can it be posted on that day?
Online you can appear on Monday. Yes.
My lord, because other connect, I leave it to
in
that.
Bangalore or in Hyderabad. For appearing online.
My lord, because I will be in Jaipur court. Yes, I will be in Jaipur court on 15th,
Come
my
up on
lord.
Monday, yes.
Not an issue.
Yes.
43, I have partly complied. Only 2-3 objections are kindly have.
Which one? Which one?
43.
Non-com, what is that? Who moved the slip?
Huh?
Memo is moved.
Memo is moved. I have already complied, but still it is showing as non-compliance.
Please show, what are the objections?
Kindly have it on Tuesday. I will comply the remaining objections also.
Annexure to be made a docket and all annexures to be attested by both commissioners. Petitioner,
That is complied.
that is complaint. Petitioner verifying
Last one is
affidavit.
still they have asked for.
Other office objection checked after complaint post so and so.
That
Text
one
to
is
be
pending.
filed.
Last
Do
one.
it. The petition shall comply with the office objections by 16th. No further time would be granted. Next.
Obliged.
Petitioner.
Yes.
Lord, this, Lord, as per Lordship's order,
Hmm.
Lord, there is no hand summons. Hand summons was not ordered. You were directed to serve the
got
copy on
ordered.
the trial court advocate. That acknowledgement has been filed by way of memo.
Hmm.
And my lord, secondly, my lord, says in favor of the respondent, it was ordered to be paid. Just said payment of arrears, my lord. So we have paid.
Post this matter on Monday.
Interim order may kindly be extended.
Interim order earlier granted is extended. Go for the petitioner.
Please.
Any urgency in this?
Nothing by-
Some memo is moved by other side.
Moved by other side. My lord, it's a matter of
Interim order is
remand.
there.
It's a matter of remand.
Hmm.
But then there's no asserts and liability statement being filed by both the parties. Not so, wife filed a minutes seeking for divorce. In the after minutes, I make an appearance, not she filed an application under section 24 seeking for interim maintenance as well as not under section 24 litigation cost. Without there being not any asserts and liability statement, not the court has passed an order. By minutes, directing me to pay a number of rupees 25,000 to the litigation cost and rupees 8,000 minutes towards the interim maintenance.
On a memo moved by the respondent, the matter is listed. No representation for the respondent. Post this matter on 29th.
Please. Interim order may kindly.
Submission, my lord.
Interim order may kindly be extended.
My lord,
What is it?
one submission, my lord. My lord, serial number 4, my lord, it got dismissed for non-prosecution, my lord. My lord, maybe restoration application may be allowed to file, my lord. I was there, my lord, much available.
No, when is it dismissed? When you are filing the registration? Now itself you are filing the registration
Because,
without
my lord,
signing the order?
otherwise it will be shared the
When
trial,
is
my
it
lord.
dismissed? Huh?
4th, my lord.
Signed. Post this that matter for, if on Monday, if you don't argue
Yes.
and again this continues.
Yes, my lord, yes, my lord.
And
My both-
that is so many times the same thing is happening. You don't come when the matter.
No, my
got-
lord, I kindly see, my lord.
Not restoration, Mr. Counsel. Why don't you come to the court?
No, my lord, it will be dismissed.
That matter, whatever it is, that number post on Monday, whatever order is.
My lord, one submission, my lord. Serial number 29, I was not there at that time. Yeah, I will file a memo for withdrawal, my lord. Or
29.
29. I'm filing a memo.
What has happened to that?
The matter has been settled, my lord. Matter gets into access.
A memo is filed 29 stating that the matter is already settled. A matter is already settled. Accordingly, the memo for withdrawal is filed. The same is taken on record and the petition is dismissed as withdrawn.
Much obliged.
Next. Send it to him. He is that, how can such a letters be addressed? How can they be, if it is addressed to the Registrar General, how can you put it? It should be on the administrative side. How can I say that transfer this petition? I should tell Registrar General to send it. Yes, ask, give it to the Registrar General and ask him to talk.